Okay, good evening, everyone. Good evening. It's okay. So we'd like to get started. I'd like to welcome everyone to our regular council meeting of October the 1st. As we begin, I wish to take a moment to recognize the traditional territory of the Sauk Nation upon whose lands we are gathered tonight. We both recognize their government and their long history and their connection to the lands and sea. Council, we have an agenda before us tonight. However, I am proposing that we are going to move the order of things about. First off, item 11.1. So after we approve the agenda, I'd like to move 11.1, the Permissive Tax Exemption Amendment Bylaw for adoption, forward, followed by 12.1, which is the Zoning Amendment Bylaw 714 for 1923 Maple Avenue. That item ended up as unfinished business from the last meeting, as we didn't have quorum. So I'd like to move that one forward, as well as 13.1, the development permit for 6736 West Coast Road, Canada Post. It was the same thing. It was postponed from September 24th. And then follow 14.1, which is a reconsideration request from myself as mayor for 6507 Water Street. Following those items, then we will move into the public hearing for 10.1 and 10.2. Oh, and the delegations. Sorry, we have two delegations this evening, which are item 8.1 and 8.2. They will follow 14.1. So the only change from what I've read out to what's on the slide is I'm moving 14.1 Water Street forward as well. Is everyone got that? Okay, so move that approval with those changes by Councillor Ray and seconded by Councillor Parkinson. Are there any questions on that? Seeing none, all those in favor? Opposed? Motion's carried. Thank you very much. So we'll start off then with...
Your Worship?
Sorry, yes, sir. Councillor
Could I
Casper.
just speak on a personal privilege, and it's not for me personally. I want to take this opportunity because we have such a large crowd here. And normally when we have something to say as councillors, there's not many people in the audience. I just think that it's important for all of us in the community and fellow councillors to recognize the work of Councillor Carrie Ray and Councillor Bev Berger. I'm assuming that this will be your last meeting. And I just want to personally thank them for their service, and it's been a pleasure on my behalf, to work with them. And I'm sure that all other council members feel the same. So thank you very much for what you've done for this community.
Thank you. Thank you, Councillor Casper. I appreciate you raising that. I'm sure you'll all stick around to the very end, though. Okay. So that brings us then to item 11.1. And that is the Permissive Tax Exemption Bylaw number 725, 2018. We do have public input, if I'm not mistaken, on this particular item. Is there anything further from staff at this point?
Nothing further.
Okay. Are there any members of the public that are here tonight to speak specifically for the Permissive Tax Amendment here before us? Twice? No? Okay, so we'll turn this back to Council. Councillor Parkinson?
Move adoption.
Move adoption by Councillor Parkinson, seconded by Councillor Casper. Any questions? See none. All those in favor? Opposed? It's carried unanimously. Item 12.1 is the Zoning Amendment Bylaw number 714 for 1923 Maple Avenue. And Councillor Pearson is declaring a conflict, so we will find him after this matter here. Two matters.
Good evening, Your Worship and Council. We're here today because the applicant is applying to amend the zoning of a portion of 1923 Maple Avenue from medium-density multifamily to RM2 to small lot residential R3. The purpose of this rezoning is to create 2 narrow lots. The subject property is approximately 0.2 hectares in size and located on the north side of Maple Avenue South. The surrounding land uses are large lot residential, R1, medium lot residential, R2, low density multifamily 1, RM1, and medium density multifamily 2, RM2. Maple Avenue South is predominantly residential in nature on the northeast side and large lot agricultural on the southwest. The applicant is proposing 2 site-specific amendments to the small lot residential R3 zone. Under permitted uses, the only principal use allowed on these new lots will be 1 single-family dwelling. The accessory use will be constrained to only limited home-based business. This restriction of the accessory uses addresses any potential parking concerns that could arise on a small lot. The second site-specific amendment is to change the minimum lot size for subdivision purposes from 350 meters squared to 250 meters squared. The minimum width, max lot coverage, and setbacks within the small lot residential R3 zone can still be achieved with a lot of this size. If the setbacks cannot be achieved through building design, then a development variance permit would be required prior to issuance of a building permit. The proposed rezoning area is highlighted here in yellow. Staff supports this application as this style of development will echo other nearby development and fits with the community residential CR, sustainable land use, and housing goals and objectives in the OCP. Rezoning on the property will negligibly impact the number of units the whole site zoned as medium-density multifamily 2, RM2, would allow. If it remained as RM2 for the entire lot, it would allow for 10 units. With this proposed rezoning, the allowed units would be 9.5. Infill developments allow for a greater range of housing options with minimal impacts on the servicing and infrastructure. The proposed lots will share 1 access off Maple Avenue per engineering's recommendations, and cash in lieu is proposed for a 2-meter sidewalk. Thank you.
Thank you, Ms. Everts. The question I have is, would these units then allow for suites to be in them?
No, that would be an accessory use. It's not permitted. The only accessory
Okay.
use would be limited home-based business, which means no one's coming or going or parking to visit your business.
And then in terms of change, then, as I understand it, currently it's 10, and then the change would be 9.5.
That is correct.
Okay. Other questions from members of council? Councillor Parkinson.
Through your worship, so for this development right now, there would be 9.5 lots?
9.5 units.
Units, right, correct. And then how many parking stalls would be included with this?
With the 2 lots, which is the only purpose of this rezoning, they're going to share 1 driveway, so it would be 1 parking stall per a lot.
Thank you.
Other questions from members of council? So should this, go ahead, Councillor Casper.
On this, will it also allow for the units to be detached as a similar development on Maple Avenue?
For the units in the front lots that are proposed, yes, they are detached.
Okay.
It would be up to whoever is developing the back how they designed their buildings.
But in the back it could be
It
detached?
could be,
Okay,
yep.
all right, very good, thank you.
Councillor Parkinson.
1.5 lots for every development, for every home, for every unit. So would they not need to have 15 parking stalls then, or is there visitor parking there as well?
The 1.5 parking stall requirement is for multifamily, and so it would not apply to this rezoning as we're only looking at the front 2 lots being created. That 1.5 would still be required on the rest of the lot, which remains zoned as RM2.
Okay. So should this pass, this will go forward to a public hearing at a future date. Anything further from members of council? Would someone like to make a motion in support or in opposition? Move first reading by Councillor Casper. Is there a seconder? Seconded by Councillor Berger. Anything by anyone else? See none. All those in favor? Opposed? That's carried unanimously. Move second reading. Second by Councillor Berger and seconded by Councillor Ray. Anything further from members of council? Seeing none, all those in favor? Opposed, motion's carried. The third part is that a public hearing be scheduled for zoning amendment bylaw 714 600-62 2018 in accordance with section 466 of the Local Government Act. Moved by Councillor Parkinson and seconded by Councillor Ray. Any questions on the public hearing? All those in favor? Opposed? It's carried unanimously. And the last part is that prior to adoption, the applicant shall provide cash in lieu for a 2-meter concrete sidewalk. Moved by Councillor Parkinson, seconded by Councillor Loggins. Any questions? All those in favor? Opposed? It's carried unanimously. Okay. Councillor Pearson has indicated that he also has a conflict with 13.1 Canada Post, so we'll just carry on and we'll bring him back after that. We have already, I can't recognize, but we have already approved the agenda with these changes to move ahead of adoption of the minutes. Yeah, we have heard public input from the last public meeting on these items at the start, but we were unable to hold quorum, so that's why these items have moved ahead. Okay, 6736 West Coast Road.
Thank you, Your Worship. The applicant for 6736 West Coast Road, better known as Canada Post, has applied for a development permit. The subject property is within the town centre and subject to the Development Permit Area Number 1 Town Centre Guidelines and Objectives, the Town Centre Plan, and the Town Centre Illustrative Design Handbook. Each speak to a high level of design in the heart of the community. Canada Post is located on the right-hand side as you travel westbound on West Coast Road and is in the town centre land use designation in the OCP. The building is set back behind a parking lot and has little architectural articulation. A blank concrete block wall makes up the majority of the facade. The proposed upgrades to the facade include extending the articulation provided by the existing canopy across the building with a wood cornice, a trellis to break up the blank concrete block wall and provide some detail around the windows, and some new landscaping to further break up the blank wall. This use of stone and rock mixed with wood and corrugated metal helped to establish a distinct, coherent look in the town centre area. On screen is the landscape plan showing existing and new upgrades to the site. The applicant will provide cash in lieu for a 3-meter paver and concrete sidewalk along the property frontage. This sidewalk will match the design of the sidewalks currently in the town centre. The cash in lieu will be received prior to issuance of the development permit. The site plan includes accessible parking directly in front of the entrance and a one-way drive aisle through the main parking lot. This parking lot layout exceeds the requirement of 14 parking spaces by 14 parking spaces and includes a dedicated loading area in the rear of the building. Overall, the updates to the existing building will help to enhance Canada Post's civic presence in the town centre and will add to the West Coast theme in the heart of Souk. Thank you.
Okay, any questions from members of council on the development permit? Seems fairly straightforward. Councillor Parkinson.
Through your worship, I'd just like to say I think this is a great development and it'll be a great addition to the town, and I look forward to the upgrades, and I'd like to move the recommendation to issue the development permit.
Okay, that's been seconded by Councillor Loggins. Anything further from members of council? Seeing none, all those in favor? Opposed? That's carried unanimously. And the second part is that prior to issuance of the DP, the applicant provide cash in lieu for a 3-meter wide paver concrete sidewalk for the town centre sidewalk design standard. Moved by Councillor Parkinson and seconded by Councillor Loggins. All those in favor? Opposed? That's carried unanimously as well. Okay. Next up is item 14.1. This is concerning the Development Variance Permit for 6507 Water Street. As mayor, I have brought this back for reconsideration. I had concerns that we were not hearing from the Sauk Nation, and there had been new business matters coming into our office. We did, in fact, receive another item today, and I'll just turn it over to staff to speak to that, please.
Thank you, Your Worship. Earlier today, Land Titles gave me a call. The Deputy Surveyor General let me know that they have changed their opinion on this property and that they now feel that the property line extends only to the present natural boundary until they get further proof that the ownership or tenure goes from that high water mark to the low water mark. This changes this application and makes the development variance not valid as it stands right now.
Are there any questions from members of council to staff on that new information that was received? You'll see in your package there was also an item that came in from the Department of Fisheries and Ocean. But at this point, I feel that the only option for council is to rescind this variance and return the matter to staff. So I'm looking, Councillor Casper, then Berger.
Yeah, I'll move that the information presented be received by council.
Okay, is there a seconder to receive that? Received by Councillor Parkinson. Discussion on the information that was presented. All those in favor? Opposed? Is carried unanimously. Anything else, Councillor Casper?
No, I would just say that you know, the situation is news to all of us, and I'm sure to the applicant too. So, and I trust that staff had advised the applicant of receipt of the letter and the correspondence from the Surveyor General. So, with that, I'll move that the previous actions by council be rescinded.
Okay, seconded by Councillor Pearson. Anything further, Councillor Casper? Anything? Anyone? All those in favor? Opposed? That's carried unanimously. Okay. Councillor Berger?
Yes, thank you. In light of the information that we received, it would be my impression that probably the majority of the waterfront tent lots in that area are going to be affected by this. So, seeing that we've received it from the Survey General through land titles, I'm wondering if it would be incumbent upon staff to send a notice out to those affected properties, because it's going to dramatically affect their land as well.
Yep, no, that's a great idea. Does council need that motion, or can staff just take that as direction to communicate
Your Worship,
that?
we'll take care of it.
Okay, and just to all the properties in that area impacted. Okay, great. Thank you, Councillor Berger. Okay, so this brings us to item 8.1. We have 2 delegations this evening, so I would like to welcome the Amber Academy, Ms. Kelly Dunn, forward for the first presentation.
And I have to excuse myself as I'm a board member.
Okay, Councillor Parkinson is excusing herself due to a conflict on this matter. Pardon me? Yeah, it's up to you. And then, Ms. Dunn, there's a 5-minute time allotment for you. If you can please keep your remarks within that time. Thank you very much.
Okay. All right. Oh, it's on once. Good evening. I'd like to start off by saying thank you very much for allowing the opportunity to address Your Worship and Council, and as well as the community for allowing the opportunity to speak as well. I am here to ask Council if they would consider a sponsorship for Amber Academy for our current 2018-2019 season. We started a program last year and had a very successful year with the program for the students in the community. We have had to incur some additional expenses to hold our classes.
Excuse me, Ms. Dunn.
Yes?
Sorry, if there's another conversation happening, can you please take it outside? It's just a little bit hard to hear. Thank you. Go ahead.
We're asking for sponsorship to help to cover an increased cost in venue space that we're paying out to hold our weekly classes. Last year we were fortunate enough to be able to use schools, classrooms throughout some of the local Souk schools. And unfortunately they weren't able to accommodate our program this year. We have moved our program into the community hall, which has proven to be a very suitable venue for us. And they've been very gracious in discounting the regular fee that we would normally pay. However, there's still a significant increase in the ability to just afford space for our class. So I am asking the district to consider a sponsorship for Amber Academy in the amount of $4,673.87, which is what we will be paying over and above the amount that we would have paid, that we had paid last year, in the amount of $3,876.13. That is brings our total projected cost for holding the classes for the year. That's from September to to June is $8,550.
Okay, thank you very much, Ms. Dunn, and thank you for all the work you're doing on this matter. So Council, you have had a request, so this would be for funds to be paid out in this year. I guess the Amber Academy would look for your plans next year and different fundraising or
Correct.
whatever for budget as should you continue to proceed in that space.
Correct.
There are questions from members of Council. Councillor Loggins?
Thank you for coming. I know that people love your program. The children love your program, and I've heard nothing but great things about it.
Thank you.
So thank you for taking that on, and thank you to your board. I have a big concern that this is not a sponsorship. This is a grant ask, and it would be unfair to other grant applicants who are looking for thousands of dollars as well to not be part of that process. Typically, our sponsorships are not quite as large, and this does go towards rent, so it wouldn't quite fit, I don't believe. But that would be my concern, is that without going through that fair process.
Understood.
Yeah.
Okay.
Thanks.
Other comments from members of Council? Councillor Berger?
Yes, thank you. My question is more directed sort of through you to staff. I agree with Councillor Loggins. I think that this is absolutely a perfect candidate for our community grants application program. So through you to staff, I'm just curious, did we have any leftover funds in the community grants?
Through your worship, no, we've fully spent that.
Okay, and then my final question is, I believe a couple of years ago when we first started using the word sponsorship, again through you to staff, we created some sort of framework around sponsorships. Do you recall? Because I think under that framework, I think this is too large, and that's why I think it's a perfect fit for the grants. But I just wanted to double check.
Through your worship, I know that budget isn't very large, so yeah.
Okay.
Some of our sponsorships are like trophies or maybe an advertisement in the amount of $100 or $50, that sort of thing.
Okay.
We do really appreciate your program. It's just with not having the funds in the community grant process or available in the fund, we're just sort of limited in terms of where we would pull it from.
Okay.
But we thank you. Our program does open up in January of each year, so
Okay.
hopefully you can get your
Perfect.
application in.
Thank you.
Thank you for all you do. Okay, our next delegation this evening is 8.2, Mr. John Nicholson. And welcome, Mr. Nicholson.
Thank
we have
you.
5 minutes for you tonight. Thank you.
Okay, I kind of wish I was a couple ahead, but we'll try and do the best we can where we are right now. Jennifer, could you put up, okay, she's got a slide up there, and I can't read it. So where do we go from here? Enlarge it. Okay, so this is foreshore and aquatic crown ownership in British Columbia, and it's got 4 points. This is off of their website, the provincial website, and it's hot off the press today. And the one that I want to point out to you is the last one. In British Columbia, the province owns nearly all freshwater and saltwater foreshore. Foreshore being that area between the high tide and the low tide. Land adjacent to the foreshore may be privately owned, but in common with law, public retains the privileges of barracks, and so on. Okay, so this key word there is nearly all freshwater and saltwater foreshore. It does not own all of it. It owns nearly all of it. Jennifer, could you stick up the next slide, please? Oh, I like that one. Okay, now I'm at 2008. Jennifer, could you kind of hone in on? I'm at the very end of Water Street here. Yeah. And so I live above Water Street, and I have 4 lots below Water Street. And those lots are registered at land titles. Now, if somebody asks me, or if I want to go and buy somebody's land, and Bev says, well, I'm of the opinion that You could just have that land. I should take that land. You operate with within the rules that you're given. Land titles say I own that land. There's 4 lots there. If you zoom in even further, Jennifer, along that, on those 4 lots, keep going. What does it show? Present, bring it down a wee bit. Present high water mark. And you see where the lots go? They go way out past. Those are the registered lots. Those lots are owned by my wife and myself. And you can have somebody's opinion. It doesn't mean, I won't say the word. Thank you. Jennifer, there's a third slide there, please. This is once again off of the BC government website. And what it refers to is a designated use area. And that basically means all the harbor and all the basin. And what it's saying is, if you want to do anything in that area, you have to make an application. And because we're negotiating with the natives on territorial ownership and control, etc., don't expect anything to happen. And that's exactly what has happened. The last 5 years in the harbor and basin, nothing has happened. And you guys furthered it by saying you got another 10 years of nothing happening. If you can focus in, Jennifer, on the area by Water Street, please. So Water Street, yeah, that's the way. Keep going. Keep going. What do you see there? Geez, those lots are excluded from the designated use area. So everything that I've looked at, paid for, and been paying for over the years, I've all done according to the book. And now you're saying, hey, John, and all your neighbors, Doug's behind me, Kevin's not here, Wilf is down at the other end, you guys don't own that now. And who says that? Well, somebody at the ministry of whatever decides, I don't think you own that. We own it. And if you want to take it away, a judge will do that. But they can't arbitrarily take it away. If it's possible, I would like you to reconsider what you did 2 steps back. Because right now, we are the legal owners, and I don't care whose opinion says what. Thank you.
Thank you, Mr. Nicholson.
I know I wasn't the main attraction, but I feel better now.
Okay. Thank you for speaking with us tonight, Mr. Nicholson. Thank you. Okay, so Council, just moving back into the agenda, we're at item number 6, adoption of minutes. We have minutes of the special meeting here from September the 17th. Move adoption by Councillor Parkinson and seconded by Councillor Berger. Okay, we have a correction on September 17th. Go ahead.
Yes, thank you. On page...
But you've seconded them, so you can speak to them.
Sure.
Okay.
I'll second it to speak to it.
Okay.
It's page 12 on here, so I'm not sure if it's different for you guys. It's under 12.5, minutes of special council meeting, under the official community plan amendment bylaw. Just under where we get to motions, it says that I moved the first motion. I actually moved the second one. So it just has Councillor Casper and I backwards. Councillor Casper moved the site-specific, and I moved the entire area.
Okay.
Thank you.
We got that noted then. Okay. Is there anything that was for, okay. Anything else in these minutes? See none, so I'll call the question. All those in favor of adoption? Opposed? It's carried unanimously. Item 7, we have minutes of the Development and Land Use Committee from September the 19th. Move receipt by Councillor Berger and seconded by Councillor Ray. Questions? See none, all those in favor? Opposed, motion's carried. There is a recommendation here from the committee, and that is that council directs staff to develop a development cost charge program for stormwater management. Would you like to speak to that as chair?
Yeah, sure. Thank you. One of our committee members brought up the topic of stormwater, and it's an excellent topic within our community because we have some faulting stormwater throughout our community. And what we realize is we don't have a way to recoup costs for infrastructure where stormwater is failing. So we wanted to direct staff to go back and look at maybe a development cost charge type of program or something that we can start so we can develop a reserve fund so we'll have cash available to look at stormwater infrastructure in the future.
Okay, I would like to suggest an amendment to the motion. I know it hasn't been moved yet, but it would be that council directs staff to provide a report on the development of a development cost charge program for the stormwater management, so that a report come to council in that nature. So Councillor Loggins is comfortable moving that, and that's okay. Okay, and a seconder, Councillor Berger. Okay, any discussion on this motion? See none, all those in favor? Opposed? It's carried unanimously. Okay, thank you very much. Anything else from the committee? Nope. Okay, thank you very much for your work as chair, and many thanks to the members of the community for their work on this committee. Okay, so that brings us to number 9, public question and comment period. So this item here is for any matter on the public hearing except for, any matter on tonight's agenda with the exception of the public hearing, because that has its own space available for it. So any other matter, though, I'd like to welcome any member public on this. Sir, if you could please come forward, and we would just like your name and address for the record, and if you could let us know which item you're speaking to, and you have 2 minutes. Thank you.
My name is Doug Bexon. I wasn't intending to speak today, but this matter of the tent lots and the letter that we're about to receive from council about who owns what. I own 3 lots adjacent to Mr. Nicholson there that just spoke. And if I could add a couple of things to what John said, is that these lots were created in the 1800s and before we were part of Canada. So there's a reason they were done like they were done. And I, like John, have title into the water. And the only thing that I wanted to say was that I recall in my research many years ago that if these lots were ever in a tax sale, the Land Act says that the ownership in the water reverts back to the high tide mark. Now, I know these lots that Wolf had were in a tax sale, and I question whether maybe that's the reason you got that response from the Surveyor General. I'm not certain. I haven't seen the document. This is all news to me. But before you start notifying everybody they don't own the property, maybe you should dig into the reasons behind that letter.
Okay, I'll just, Mr. Blackhall.
Yeah, thanks, Your Worship. The reason the Surveyor General has responded is due to the current application. It has nothing to do with the tax sale that previously went through. And it's a Surveyor General's opinion that they've taken that stance. It's not staff. So
I understand that. I'm just puzzled. These Surveyor General has accepted and registered these lots. I know myself, John and myself. So I don't know where they could come up with the idea that they accepted registrations for property that aren't real. So I just thought I would offer that because I'm puzzled as to why this is happening.
Okay, thank you, Mr. Beck. So maybe perhaps if you could set an appointment to meet with our staff, and then you'd have the opportunity to get more answers.
Meet with the Surveyor General.
Or the Surveyor General, for that matter. Thank you, sir. Other members of the public on tonight's agenda? It is everything but the public hearings.
Thank you, Your Worship and Honourable Council members. My name is Lonnie McPherson. I live at 2015 Kennedy Street. I'd like to speak on the same issue, actually, item 14.1. In light of the decision this evening I'd like to highlight that there has been a lack of enforcement of the bylaws by the district staff. As the staff report on this 6507 Water Street notes, the applicant is in contravention of Bylaw 561 by building a concrete seawall 2.7 meters past the present natural boundary and by landfilling the lot without prior approval. The adjoining neighbors first reported this contravention to district staff back in March, again in May to a staff engineer who took pictures, and again to staff in early August. So I leave that with you to deal with. Thank you.
Thank you, Mr. McPherson. Other comments or questions from members of the public this evening?
Ellen Lures, 5526 Road. I just wanted to comment on your minutes because your video was down, so there's information that didn't go out, and it's not in the minutes either. But staff had said to what the cost would be to send out to all the OCP members affected would be $900, which is around 900 properties, and I remember Councillor Casper not being in favor of it, but that isn't in here. He didn't deem it necessary, but that isn't in here, and that would also help people to understand that there's 900 properties affected. Thank you.
Thank you, Ms. Lures. Other members of the public have any comments on tonight's agenda? No? Okay. So moving on, thank you very much. This brings us to item 10.1, OCP, Official Community Plan Amendment, Bylaw 722, and I'll turn this to staff, please.
Thank you, Your Worship, members of council. There is no presentation for this particular item, as there wasn't at the first and second. This is a minor correction in the OCP where a portion of property is shown as agricultural because it was assumed it was in the ALR back in 2009 when the OCP was adopted, 2010, sorry. And through an application process, it was determined from the ALC that it is not in the ALR, so this is a map correction.
Okay, this is a housekeeping item. Okay, so we've moved first and second, and tonight's the public hearing. Is there anything further from members of council before we go into the public hearing on this? Okay, so I just have this statement to read, if you bear with me here. This public hearing is being held pursuant to the Local Government Act. At this public hearing, any person who believes that their interest in property is affected by the proposed bylaw will be given a reasonable opportunity to be heard or to present written submissions respecting matters contained in the bylaw that are the subject of this hearing. Copies of written submissions received to date are available. We have none on this particular item. It is important that all who speak at this hearing restrict their remarks to matters contained in the bylaw, and it is my responsibility as chair of this hearing to ensure that all remarks are so restricted. For those of you who wish to speak, please at the appropriate time commence your address to council by clearly stating your name and address. Then you may give us the benefit of your views concerning the proposed bylaw. Submissions must be received before or during the public hearing in order to be considered by council. Members of council may, if they so wish, ask questions of you following your presentation or submission. However, the main function of council members this evening is to listen to the views of the public. It is not the function of council at this hearing to debate the merits of the proposed bylaw with individual citizens. Everyone who deems his or her interest in property to be affected shall be given the opportunity to be heard at this hearing. No one will be or should feel discouraged or prevented from making his or her views known. Please note that this hearing forms part of tonight's regular meeting of council and as such is being video recorded. Videos and their contents, including any personal information disclosed during the hearing, will be posted on the district's website. So on that note, I'd like to welcome anyone forward for the map amendment for this particular bylaw.
I understand that this is seen as a map.
Sir, if we could have your name and
Kevin
address.
MacArthur, Riverstone Drive. in the Sunriver community. I understand that this is seen as a housekeeping correction, but correct me if I am wrong, was not the buildings on there used for farming purpose? I believe it was a barn built under the Farm Act. Am I incorrect on that?
Well, thank you. Turn that to staff.
That's possible that historically there was some farm buildings on the site, but the ALC is the body that provides us with the mapping of anything that's considered ALR, Agricultural Land Reserve, and they have determined that this portion is not in the ALR.
Right. So if the property was successfully used for farming, then I would argue that it could be continued to be used for farming, could it not? So I don't want to go back and forth, but my question would be is if there are farm buildings built for farming purposes on land that's no longer in the Agricultural Land Reserve, that doesn't preclude the district from maintaining an agricultural zoning on it. So those are my comments.
Okay.
Through the chair, through your worship, the official community plan has a land use designation for agricultural lands, and it's based solely on the Agricultural Land Commission's mapping of agricultural land reserves and their qualifying factors for those lands.
Other members of the public on this particular item, the Community Plan Amendment Bylaw? We'll call for a second time if there's other speakers. And call for a third and final time. Okay.
Tony St. Pierre, Phillips 2385. I was here in the last meeting when we talked about, or not when we talked about, when you guys talked about this particular issue. And one of the things that I noted at the time was that by and large, because we're in a situation where we're trying to find a right and wrong, we're in some ways looking for a guilty party. Now, I'm wondering, is this the right time to be speaking about?
No, this is a housekeeping amendment that could have likely just come through at any point in time, as I understand it.
So this is just fixing up your maps?
Yes.
Okay.
We have another public hearing to follow.
Another one to follow.
Thank
Lovely.
you.
I'll hold on.
Okay.
Thank you very much.
Thank you. Final call for members of the public on the housekeeping, on the map amendment. Okay, so I'll close the public hearing then and turn this back to council. I'm looking for someone to give third reading, please. Move third reading by Councillor Ray and seconded by Councillor Parkinson, as that council give third reading to the bylaw cited as Official Community Plan Amendment Bylaw number 722-400-11-2018. Moved and seconded. Any further questions? See none. All those in favor? Opposed? That's carried unanimously. Ms. Mushata?
Yes, thank you, Your Worship. There's no outstanding issues with this, and as OCPs and zoning bylaws do not require 24 hours between third and final reading, so this can also have final reading this evening.
Okay. Move final reading by Councillor Ray and seconded by Councillor Parkinson. Any further discussion? All those in favor? Opposed? That's carried unanimously. Okay. Thank you. So moving into our second public hearing. Official Community Plan Bylaw 724. And I will turn this over to staff, please.
Thank you, Your Worship. Council will just allow a moment for the presentation to come up. Last year, the applicant, Sean Drivers, applied for a business license, which ultimately was refused by council. He was then advised to submit a rezoning application in order to move towards conforming with the zoning bylaw. Review of the proposed zoning, which was C3, resulted in staff advising the applicant that it would not comply with the official community plan gateway residential designation. Staff investigated alternative solutions, all of which are laid out in the council report and were reviewed by legal counsel to their appropriateness of the options, and also the wording of the recommendation before you was vetted with our legal counsel. On the screen is a snapshot of a portion of the OCP land use map. The amendment before Council today applies to those areas of the map depicted in orange as gateway residential. Of the alternatives reviewed, the text amendments to the OCP in option 4 of the report are recommended. The amendments would provide an avenue for applicants to request from Council temporary approval for historic, non-conforming, non-residential uses on residentially zoned properties. A temporary use permit may be granted for up to 2 years with one renewal for an additional 2 years. It is Council's discretion if they choose to grant it for less than 2 years. A temporary use permit may also include conditions such as, but not limited to, specifics around the layout and aesthetic of a site, operating hours, buffering from adjacent neighbors, and other things. It may not include new construction for permanent structures. This amendment will offer time for Council to more strategically assess the gateway residential area through a full OCP review in 2019. That concludes my presentation.
Thank you. Can you please just go back to the slide with the map that doesn't have that box on it? So, in fact, it's the areas in orange, and then also there's a few areas up Souk River Road and the like. It's all in that area. Okay.
That's correct.
And temporary conditions, as you had mentioned, would, in order for that to be granted, conditions like hours of operation, if there's buffering near an environmentally sensitive area, would all have to be done. Some sort of a qualified, I don't remember now what the acronym stands for, but by a qualified individual to provide that. And this process, in any case, would come before Council. So an applicant would choose to make this application, submit it to staff, staff receives a report, then it comes forward to Council in an open meeting, and then there is a public hearing that goes with that, just so I'm clear on the process?
That is correct, Your Worship.
Okay. Questions from members of Council? Councillor Casper, then Ray, please.
Yeah, through you to staff. So I just want to get it clarified with staff. Through you to staff. I just want to make sure I understand this, and for the public's benefit, that the large area, which is all of the gateway classification, was recommended by our lawyers that this was the action to be taken, correct? Number 4?
Through vetting all of the options with legal counsel, this was the most appropriate and agreed upon option, yes.
Okay, thank you.
Councillor Ray?
Yes, through your worship, to the head planner. There are, just for the audience that is here, there are 3 areas in the larger orange. One is a light blue that runs along the highway. One is in red, which is the peninsula, the Goodrich. And then there's a green one just above it. Can you tell us what those colors in the gateway reference?
So, yeah, the coloring's a little off on the screen, but so Goodrich Peninsula, the cross-hatching there is for a comprehensive development zone that would be developed, but it would have to comply somewhat with the gateway residential land use designation. The intent is for redevelopment to have a comprehensive development for that site. Sorry, could you repeat what other? So the light blue depicts the agricultural land use designation, so those areas are in the ALR, or the agricultural land reserve. And then, yes, sorry, yes, through your worship, that is park. The darker green is all park space.
Thank you very much.
Okay, Councillor Parkinson, then Loggins.
Through your worship, I was wondering if we have any idea how many businesses are operating that are non-conforming in this area?
Through your worship, staff cannot verify the number of businesses, but there is some understanding that there may be 2 to 3 additional potentially.
And would that include legal non-conforming?
Legal non-conforming is a separate and I think it's probably better for this audience for me to clarify the difference. Thank you for that question. Legal nonconforming speaks to a use that was approved under another jurisdiction or another bylaw prior to our current bylaws. So they already existed and were approved, and so they become legal nonconforming. But in the time that they might want to redevelop their site, they must conform to the current rules and bylaws. So there are some businesses in that area that were recognized through the OCP process as legal nonconforming because they had approvals previously, either from the CRD or under a different bylaw from the District of Sauk. But if they were to come in for a large addition that would require a development permit, they may in fact need to go through rezoning in order to comply. Non-conforming are those that have never had an approval in the past by either the District of Sauk or any other jurisdiction.
My next question is, what happens with the legal non-conforming businesses that are operating now if we change the OCP for the gateway residential? Why would these people want to change? Because now they're able to operate for life, and if we put this in, then they can only operate for the 2 years and have an extension maybe for another 2 years, and then they have to convert. Why would they want to do that?
Through your worship, this amendment does not impact the legal non-conforming. This is for historic non-conforming.
Okay. Thank you.
Councillor Loggins.
Thank you, Your Worship, and thank you, staff, for the work that you've put into this. I know it's been a long journey. My question is around the temporary use permit. I know that council shouldn't be seen as aiding individual businesses or special interest groups, so that kind of plays into my question here. But I'm curious if staff can confirm that temporary use permits can be granted in other areas of the District of Sauk, but only the commercial lots, is that right? Or are there other areas?
Through your worship, thank you for the question. Temporary use permits are guided by the Local Government Act and can be issued on commercial or industrial lands for commercial or industrial uses. Our zoning bylaw, section 3.33, under the general regulations, also identifies the ability to apply temporary use permits in a number of our CD zones, and typically in the areas of those CD zones that are mixed use, so have some element of residential, and then other commercial uses in them.
Thank you. Yeah.
Through your worship, to segue into that, if this amendment was approved, a minor amendment to the zoning bylaw to section 3.33 would be required to add reference to this amendment.
Thank you. That's kind of what I was wondering, because this kind of creates, this particular change creates an inequity for the whole community if we don't amend the section 3.33 as well.
So that amendment would be brought forward by staff if this amendment were to go forward. And in my opinion, that would be a minor amendment. Their legal opinion was that we don't typically see in a zoning bylaw a list of areas where you can apply a temporary use permit, because the Local Government Act addresses that and our OCP addresses that. It just so happens that at the District of Sauk we have it in both areas, so it would be incumbent upon us to then add the reference to this potential amendment in that section of the zoning bylaw, which I would bring forward at a later date.
Thank you.
Councillor Casper?
Yeah, through you, just further to that. So if this was approved, then any person who wanted to then get a temporary use permit would then have to apply for that permit, and then there would be another public hearing process. Is that correct?
So through your worship, so again, this would be anyone that has a historic non-conforming use. They would have to apply for a temporary use permit. Notifications would have to go out to adjoining properties within 100 meters. It's not technically a public hearing, but it must be heard by council, and the public can comment on it.
And to clarify, when you mention historic being a date up to what point? Adoption of the 2010 OCP? Or when would that apply to be historic?
Through your worship, when I was considering this, my interpretation as the planner would be that it's prior to adoption of our existing OCP, but I would leave that in the hands of council if they wish to decide on what historic means to you.
Okay, I think that should be, I mean, my understanding would be the same as yours, that it would be with effect of the OCP in 2010. Councillor Parkinson, then Pearson.
Through your worship. Then that means anybody before the OCP was adopted in 2010 wouldn't be able to apply? No.
No, through your worship. It just is the definition of what we would say historic means. So if you're coming in, say a complaint was received because someone's operating a business without any approvals, they're non-conforming, they could have the opportunity to come in for a temporary use permit for historic. They have to prove they're historic. They've been operating since prior to the OCP being adopted.
So then that says to me, then the property that has been discussed would be okay because it was prior to that, it was just after incorporation when the property was purchased.
Through your worship, they still have never had any previous approvals. So going through the temporary use permit allows council to determine if they want to approve that use and allow them to conform for a certain period of time.
So just for me personally, I would think that historic would mean since incorporation, so that it has nothing to do with when we were a regional district, but as soon as we incorporated, everything from day one of incorporation would be historical, in my view.
Ms. Machado?
Thank you, Your Worship. If I could just speak to that. When the district incorporated, it adopted the CRD's official or zoning bylaw and official community plan for a period of time, which I believe was up to 4 years, if memory serves. I think it was 2004 they adopted their own. No.
2001, I was just in my archives, found a 2001 date.
That's the OCP?
Yeah.
But I believe the zoning bylaw was 2004, which covers the land
zoning bylaw.
uses.
Okay, got it. Thank
so
you.
Those properties would be legally non-conforming had they been permitted the use under the CRD bylaws.
Go ahead.
Through your worship. So when we look at our OCP text amendment and it says zoning amendment, it says to allow for temporary commercial use permits within the gateway residential land use designation. That says to me, excuse me, that anybody in that entire area can apply for a temporary permit, not just historical properties.
Through your worship, the wording of the bylaw, sorry, I'll bring it up here. Permit by temporary use permit the continuation of historic, non-conforming, non-residential uses that are outside the scope of a home-based business regulations. So this would be the bylaw attached to the report.
Okay. Councillor Pearson?
Yes, through your worship, I have a lot of questions. So if a temporary use permit is granted, what safeguards the concerns that are out there? So first of all, my first question would be, to come into compliance, is it done by way of 219 covenants at the time of, would 219 covenants be applied in the temporary use permit?
Through your worship, that's a good question. I don't feel that would be necessary. You would condition your approval of the temporary use permit, and you would choose a time, and it doesn't have to be for 2 years. It can be for less. And at which, if through that time period they're not meeting their conditions, if there's an ongoing conditions regarding operating hours, lighting of the site, things of that nature, and they're not meeting those conditions, and we know about it through complaints, then they don't get to continue on the operations and extension of their temporary use permit, and in fact, we could pull the temporary use permit.
Okay. Next question, through your worship, is what about the tax rate? Because I've heard numerous complaints from across the community about the tax rates inappropriate. It's probably a question through to our CAO. So would the tax rate with a temporary use permit be changed to reflect the assessed value of a current use?
Through your worship, the classification is determined by BC assessment. So for this particular property, it's classed both as residential and commercial. already, and it has been for a number of years. There was a brief time where it was industrial, but I believe that was only for 1 year. So there has been commercial taxes being paid on it. That wouldn't change unless BC Assessment decided they needed to review the classification of the property.
So, follow-up question to that. So, if a temporary use permit was granted, the notion would be drawn from me personally that it's an approved use for a time frame, and then the tax rate for that amount of land would reflect other land parcels of the same size within the district. Is that true or not?
Through your worship, BC Assessment uses, a highest and best use kind of process to determine the best use of that land. I would imagine they're looking at our zoning, what it allows, what it doesn't allow. They've determined that this is a commercial business operation versus industrial. They may not be aware of this current temporary use permit if it was to be granted, but they do review the properties on they do audits, desk audits all the time, and they're aware of the hot and button kind of properties around here, and they kind of are looking at them anyway. So.
Okay, so I think you answered, but I want to make sure that I'm clear through your worship, is that BC Assessment doesn't necessarily have a vehicle to bring in temporary use permits, or is there a section that says that?
Through your worship, I'm not aware of one personally. I mean, if they're watching this council meeting, or if they see something on file, on title for this property, they would then maybe consider reassessing it. But it's already classed as commercial. So,
okay. Yeah. And the reason I'm asking is because I've been asked that in the public. What safeguards have you got about making fair tax assessments against this property if you granted a temporary use permit? So that hence my questions.
Through your worship, if it didn't have commercial classification, we would be concerned about that. The fact that it does and has for quite a long time. And it's up to BC Assessment Authority whether they want to visit the property and reassess it, maybe change the proportion of it, or maybe consider it to be industrial.
Okay. One more question, if I may. Back through to our Director of Planning. So the safeguards, as the immediate neighbors, raised a number of concerns, and they've told me as well. So what about there's no process in place as noise abatement? A concrete fence or something could be a condition of a temporary use permit. I want to I'm trying to focus in on this 219 covenant piece. So.
A 219 covenant isn't necessarily required. If council is reviewing a temporary use permit and determines either through staff's recommendation for remedial actions that they would approve it conditional on the following things occurring, then that's what should happen. Otherwise, the permit would not, in my opinion, should not be issued. So there can be approval and then a prior to issuance conditions.
And then would said approval then also necessitate a site visit from our staff to ensure that the conditions are met before the permit's granted?
Absolutely.
Okay. And just a question in regards to taxes. The district, does it have any ability to collect taxes from like 10 years ago? So if someone said, well, this was a business for this long, we'd like to see commercial taxes paid, is there a mechanism to do that?
Your worship, no, I don't believe so.
No, okay.
We get supplemental adjustments from BC Assessment due to property appeals. We get those all the time. And, they go both ways, mostly in favor of the applicant, it seems. And it's a big problem for us to deal with. But I've never, been aware of any retroactivity. No.
So that's why there's the 30 days. Once you receive your assessment notice, landowners would have that 30-day to appeal or to make changes to it, and then it's finalized. The municipality receives that information, and then you prepare accordingly based on that finalized piece. Okay, got it. Councillor Casper?
Through you, just as a follow-up on that, is it not correct that a third party can actually ask for another party to be looked at or reassessed?
Through your worship, that's correct.
Other questions from members of council? Nope. Okay, so we will proceed into the public hearing. Pardon me. Okay, so before we do that, the applicant has the ability to make comment, as I understand it. Okay. Please come forward and introduce yourself. The microphone is on.
Sean Driver, 5536 Souk Road, owner of the property in question here.
My name is Aurora Faulkner Killam. For the purposes of this proceeding today, my address is 26 Bastion Square. I'm a lawyer with Cox Taylor, and I'm here to address some of the aspects of the application with Sean. My firm practices in the area of municipal law, as do I, and some of these comments that are under discussion and of interest to all of you to do with lawful non-conforming use fall within an area that I practice in. So when I'm speaking about what a court might consider or what would be relevant to the inquiry, I'm doing that with the background to say that I've seen it and I know what is relevant in these areas. First of all, I wanted to just raise for you that we have an outline of submissions here, and I'm not going to read it to you all today, but I have included in it at the bottom of the 5th page and carrying over to the top of the 6th page, a section of the Local Government Act called 528. And that's the section that creates protection for lawful non-conforming uses. And that section says that when you have land or a building or structure that is being lawfully used at the time that a bylaw is adopted, and the use does not conform to the bylaw, it may be continued as a non-conforming use. And the significance of that is that this section, or its predecessors really, has been the most consistently, broadly construed section under the Local Government Act that I'm aware of. And the reason for that is that it is one of the critical ways in which the rights of property owners are balanced. Balanced with the power of council and balanced with planning of the majority. This protects the decisions that people make when they purchase land. So we're here today because there's actually a rare opportunity to avoid a dispute. Lawyers like myself are very prone to giving our opinions and running into court. But it's actually a rare day when you find a property owner who is actually more concerned with finding a solution. And that is part of what we are looking to do. So I think it's important to understand that in the context of lawful nonconforming uses, there's a problem that comes from institutional memory, where you have a group of people who are interpreting a certain set of bylaws, a certain set of controls at a given point in time, and over time those people change. There will be tendrils of information that's left over in the form of correspondence, communications. In my business, we call that evidence. But the interpretation might start to shift as over time the planning itself shifts. So there will be amendments to the zoning, amendments to the official community plan. And suddenly, looking backwards in time, it's easier to try to make a rationalization that something what didn't used to be allowed, when in fact, at the time, it was. Or at the time, the interpretation of the people who were actually in charge of making those decisions was that it was permitted. And that's significant in interpreting correctly the intent of the bylaw, and that is the task that a court would engage in looking at a situation where you have a landowner who's been doing something for a very long time with what appears to be the approval, blessing, knowledge of the local government. So it's important to understand as well that the categories of what is allowed under zoning are not always cut and dried, and this can be very challenging for people who are new to it or people who don't do that kind of analysis every day to appreciate right away. If you are allowed to undertake a certain use like repair, you are actually allowed, generally speaking, to undertake incidental uses as well. And so that can include things like welding. Evidence of intent comes from how zoning is historically interpreted. And what I would say to you generally is that in my review so far of the information that applies to this property and these uses, the evidence discloses that from the start, these uses were considered to be within what is permitted. And that over time, there may have been a thinking shift, but that doesn't allow you to go back in time and take away those rights. And I brought a section of a case, and I don't want to run out of time, so I'm just going to read you bits of it. The case is called Sunshine in Bailey. And it was actually what's called a commitment to use case. And so you understand the context for that. You don't even have to have a structure built. You can have a foundation. You can have roads put in, but not everything done. And as long as you've sufficiently committed to the use, the law actually protects it and allows you to finish it. And they do that on the basis of fairness. And these are extracts from this case where the Court of Appeal said, presumably, it is the concept of fairness that supplies the underlying rationale for the statutory non-conforming use exception. And I'm skipping a little bit. It says, any doubts as to prior use ought to be resolved in favor of the owner. And it also says that going back and trying to do the retroactive look at things savors of unfairness because it is tantamount to giving the zoning bylaw retroactive effect to the prejudice of the owner. So what that means in application is that where you have ambiguity, where you have words that might allow a use, sort of, kind of, maybe, and you have other words that you think maybe don't allow the use, but the interpretation historically was that the use was permitted, courts generally will protect the owner's use in those cases. When I say I deal in evidence, I mean that. And I'd refer you to a document that in preparing for this evening I noticed in the application. It wasn't one I'd seen before, but it's at page 325 of the materials that have been submitted. And I think it's worth pointing out and taking the time to point out because it's the kind of thing that lawyers jump on. This is the 325 of 443, and it's an email from 2007. It appears to be written from a Larry Daw at the District of Souk, writing to an Evan Parliament at the District of Souk. And he says, Evan, thank you for the warning. This has been a long-time issue which has been approved by Frank Limshew, the planner at the time, after a site inspection that he and I made. And he says he didn't agree with the conclusion. But as it was 2 years ago, it will not be an easy enforcement, as Sean correctly believes that he has district approval to operate as he is, unless he has significantly changed his operation. So this is a significant factor, one among many, that I would say a court would look at very closely, and they would have great regard for protecting what they see as falling within the scope of permitted uses on this property. So now that I've said all that, I'm going to come back to the point that I made already, which is this property owner wants a solution and is prepared to come forward on the basis that he says he has a lawful nonconforming use. But he's prepared to look at what is a solution that is going to work for everyone. What is a solution that is going to normalize the existing uses and be in the interest of the community because it will put everyone on the same informational playing field. And so what I mean by that is you can have planning documents, OCPs, and zoning, all of which make certain things lawful expressly. But as long as there are people who have been doing those things for a time prior to that, those people's uses actually aren't part of the planning documentation. And people who live in the community won't have the same notice of them. They won't understand that they exist, and they might misinform themselves about what is allowed. And so going through the process of normalizing these activities, allowing people to come forward on the basis that they wish to be part of the solution, in effect, is, in my respectful submission, a very, very good thing. So the document that I've prepared, as I indicated, I won't read to you. Part of the purpose and intent is to ensure that at least the record is clear about some of the lead-up that got us here. And the first 2 and 3 pages cover a fair amount of that. In the 4th and 5th page, I've set out the analysis that, or part of the analysis that would be presented in court if necessary. And that leads to, ultimately, the final conclusions today, which is on behalf of the applicant at this time, which is that the building is one that, pardon me, the business and use is one that is of great benefit to this community, that has been of use to the district and should continue to be so. And so Sean wanted to say a few things.
Yeah, very well done. I've come before staff for years on this and done everything I was directed to do. Got nothing to hide. I've invited everybody down there, fire marshals, whoever. So here we are. I want to work with the district. You know, we do a lot of community work, and I want to work with the neighbors. Since we were here 2 weeks ago, first thing I did the very next day, after the Monday night council meeting, is I said to my staff, we're going to build a fence starting this morning. So I contacted Ivy, the planner, to get the exact regulations on the fence before I started, because I figured something might come up. So we built the fence to be neighborly. I didn't have to, I did it because I wanted to. Regarding AM Creek, we've already started taking some stewardeships towards that by removing the ivy off of the trees that it's killing down there. For years, we have a lot of maple trees down there that should have been cut down 20 years ago. They're dead. They're falling down every winter. We lose some branches. There are some trees over the home down there that are a liability, and we were asked to stop to cut them down, which is a major concern because there's going to be personal injury. It's right over a bedroom. So there's things I want to do reflecting the creek to work with repair and assessment. I'm all for it. I got no problems with that at all. And we weren't asked to do that. I've offered that, to do that. So I'm here. I just want to get this resolved. That's why I'm here. And I've done everything I've been directed to do. Every time I come up and ask to do something, I've taken those channels. And here we are. So, any questions?
Questions, Councillor Loggins?
I do have some questions. My first is, do you have any case law for non-conforming? Not legal non-conforming, non-conforming, because that is the issue in this case.
Well, respectfully, there is a disagreement.
Oh, sorry, I'm just wondering if there's case law for that you have with you as an example. If not, I'll continue.
If your question is whether or not the use is non-conforming,
No, it is not. My question is whether you have case law with you, yes or no.
The answer is that it is disputed whether or not it is non-conforming or lawfully non-conforming.
It troubles me greatly that you come here speaking specifically about lawful non-conforming, because I strongly believe that it is non-conforming, as our staff and legal has suggested as well. And also, it's interesting to me that you reference Larry's letter in 2007, because in 2004, Frank, who you referenced as well, wrote this one, which I'm sure you have, but just neglected to reference. It has come to our attention that you may be using the barn building for commercial welding activities. If so, I ask that you cease and desist this activity immediately. Your property is currently zoned agriculture. The use permitted under the zone are attached for your uses permitted under the zone are attached for your information. I also draw your attention to conditions of a home-based business. Please note that Section 4E, related to home occupation Category 3, limits this use to a maximum of 645 square feet, or not more than 40% of the dwelling unit, whichever is less. Our bylaw enforcement officer will be contacting you for a site inspection to ensure compliance with our bylaws. And that was from Frank before Larry, who didn't agree with Frank, passed on the information that that was not true.
Respectfully, Councillor, that is actually referenced in our submission on the first page. I did not read it because I had assumed that was old news, but thank you for the opportunity to clarify. Sean's evidence has always been that following receipt of that letter, a site inspection took place, at which time it was determined that his use was appropriate.
I do not have any evidence of that, and I don't believe anyone here does either. So if you do have that evidence, it would be great to bring that forward. I did receive this today, the second I walked into council. Now, we've known this has been going on for a very long time.
Excuse me, that was submitted on Friday in its entirety. I was advised it didn't make it into the binders by
It wouldn't,
dint of an
no.
accident.
It would just be prepared and delivered to council right now. So unfortunately, we have not had time to look at this, even though this case has been ongoing for quite some time. The next thing I'd like to mention is that according to our timelines, it is very clear that it is non-conforming and not legal non-conforming. Thank you.
Was that a question?
Okay. Is there anything further any questions from members of council? Anything further? Okay. Go ahead, Councillor Casper.
Just through you to the applicant, I've heard nothing from the applicant in regard to the 10-year span between 2007 and 2017, where council's been advised that there is no record of any activities or action taken by anybody. Were you aware of that?
Thank you for the question, Councillor Casper. The position of Mr. Driver and his evidence, as I understand it in these proceedings throughout, has been that at various points in times he has interfaced with the district, inquired if he needs business licenses, for instance, and had the status of his lawful non-conforming use status confirmed, and has continued to do business with the district thereafter. So in terms of that period of time, I'm not specifically aware, unless Sean would like to correct me.
The last correspondence from the town was when you're talking about the 2004 letter. They come out for a site visit. Yes, they did. And at that time, I was told verbally right then and there, and I guess that was a mistake, I never got it in writing, that it was a home-based business, that it wasn't an issue because it was never brought up again. And then the following year, the town started hiring my services and using me every year to currently. So that would lead somebody to believe that you're doing nothing wrong.
And from 2007 onwards?
I'm talking from 2004, right, 2005 to present day.
All right.
That answer your question, Councillor Casper? Councillor Parkinson?
Through your worship, I think this got a little bit out of control in that this is a public hearing for an OCP text amendment. It's not in regards to any specific property. It's not in regards to anything that's going on with this property. This hearing is about the amendment, and that's all we should be talking about, everybody here. Thank you.
Thank you, Councillor. Okay, so we are going to proceed into the public hearing. So, read my statement. Just give me a minute here. This public hearing is being held pursuant to the Local Government Act. At this public hearing, any person who believes that their interest in property is affected by the proposed bylaw will be given a reasonable opportunity to be heard or to present written submissions respecting matters contained in the bylaw that are the subject of this hearing. Copies of written submissions received to date are available. And it is important that all who speak at this hearing restrict their remarks to matters contained in the bylaw, and it is my responsibility of chair of this hearing to ensure that all remarks are so restricted. For those of you who wish to speak at the appropriate time, please commence your address to Council by clearly stating your name and address, and you may give us the benefit of your views concerning the proposed bylaw. Submissions must be received before or during the public hearing in order to be considered by Council. Members of Council may, if they so wish, ask questions of you following your presentation or submission. However, the main function of Council members this evening is to listen to the views of the public. It is not the function of Council at this public hearing to debate the merits of the proposed bylaw with individual citizens. Everyone who deems his or her interest in property to be affected shall be given the opportunity to be heard at this hearing. No one will be or should feel discouraged or prevented from making his or her views known. And please note that this hearing forms part of tonight's regular meeting of Council, and as such is being video recorded. Videos and their contents, including any personal information disclosed during the public hearing, will be posted on the district's website. Thank you. I'd like to welcome any member forward to speak on this matter.
Thank you, Mayor and Council. Derek Lewis, 5526 Souk Road. And thank you very much, Ms. Loggins, for her comments. I want to applaud the great show that was put on by the legal team for Mr. Driver. I felt like I was on Perry Mason here, and this is supposed to be a public hearing, not a court of law. I felt that was very unfair to that presentation to put a legal argument to Council and feel that there's a pressure of a precedence coming for a legal case. The district's lawyer is not here to answer any of those questions or refute any of the comments, and I think that was very incorrect. Ms. Faulkner commented on this use that it was not being permitted. We have a staff report, presumably legal for the district has been involved in this case from the get-go. You have a report that's been reprinted for you several times that is stated, and the corporate secretary can correct me if I'm wrong, that this use has never, ever been accepted. It was never a home-based business. It never fell within any of our table of concordance for our bylaws. It was always just illegal. I'm loving the term that we've coined here, and we're now calling it historic non-conforming. I think that, maybe the planner can correct me wrong, would the illegal be the same interchange with that word, historic non-conforming? I'm asking. Okay. There's been no ambiguity in any of the comments that were made. Councillor Loggins pointed out the other communications that the lawyer left out. And I would say that the presentation that was made by the legal team there said that, there's a balance here between the laws and what we need to do. And I would wonder why we have bylaws. If everything that we have for bylaws is, it's subject to interpretation, and, if you just do it anyways, and then you can just call it historic, and then you can just keep going, then we might as well fire our entire staff. We don't need bylaw enforcement. We won't need planning and engineering. So I would submit that those comments were actually very incorrect at the moment, and that's what I got to say at the moment. Thank you.
Thank you, Mr. Lewis. Other members of the public here to speak tonight? Councillor Casper, yes?
Just as a precaution, I don't find the comments directed at staff appropriate. I don't think that's fair. This is a workplace. This is a workplace, and I think that should be respected. We're here to talk about a bylaw, and we're not here to discuss the merits of any staff report or their conduct. I find it highly inappropriate, and I won't tolerate it. This is a workplace. It must be respected.
Thank you, Councillor Casper. Go ahead, Mr. St. Pierre.
Tony St. Pierre, 2385 Phillips Road. As it happens, I do have a background in planning, and one of the things that I'd like to speak to right away is just the work that the planners have done in terms of finding a solution. I think they've done good work. I don't have the experience, actually, to appreciate it as much as I might. But the bottom line is a lot of people are worried that this is going to be a gateway in the gateway area. And it's not. It simply isn't. This only applies to very few places. It is very different when you have something that's legally non-conforming. This would definitely have to have been previous. It's only going to apply to a very few places that can then deal with it appropriately. It's not a floodgate of chaos coming at the OCP and trying to erode everything out. So I think the community has been worried about that. I just like to point out that it's not really an issue. I think the thing that I've noticed and I was trying to speak to before is just that this has turned into a bit of almost a legal proceeding with you're right, you're wrong, a lot of punitive action being looked at. I think Mr. Driver has lawyered up because I think he's rightfully afraid for his livelihood. I think there's room to actually look at what everybody needs here before moving ahead. We have Mr. Driver who's been operating a business for a long time. He's expanded. He's made use of his resources, and he's done it illegally. But he got a cease and desist 14 years ago that wasn't followed up on. Now, I think that speaks to a municipality that was just coming into its own, didn't have the experience to deal with the issue, didn't necessarily follow up. So the municipality has some fault to bear. Neighbors didn't actually follow up with a proper complaint process. I guess they're not innocent either. They didn't know how to complain properly. The salmon would probably like to live without contaminants too. They can't complain properly either. In all of this, I think that what I'm noticing is that we're not necessarily looking at the good, we're looking at the right. So one thing that I agree with Mr. Driver's lawyer is that we should be looking at the good of the community, and part of it is actually going to be try and maintain businesses in the community. Now, as it happens, we also need good governance. The municipality can't be seen to be allowing anything to happen. Mr. Driver must cease and desist industrial activity. This has to stop. You've got property owners that are likely to sue because their property rights are being infringed upon, their property values are going down, and they're not able to enjoy their property. But I would suggest that instead of spending money on lawyers and on legal fees and on settlements, it might be appropriate to see about developing an industrial site in Souk that might actually offer better property taxes for a period of time to any local business that wants to set up for industrial use. This gets around the problem with municipalities not being able to assist business owners individually. So Mr. Driver would not be getting special treatment. Instead, we're encouraging any businesses and all businesses into Souk in an appropriate place to do so. The permit process allows Mr. Driver time to move over. The incentive of lower property taxes during a period of time helps him pay for it. It may not be punitive, but it would allow us to have more business in Souk and to potentially provide a solution. And there might be others, but that's what I've got to say. Thank you.
Thank you, Mr. St. Pierre. Other comments this evening from members of the public? You come forward, sir, to the microphone.
Okay. Thank you. My name is Mick
Sorry,
Rhodes.
you could just speak into the microphone, sir.
7885 West Coast Road, Mick Rhodes. Just a preemptor. I'm running for mayor, everybody.
Direct your comments to me, please, and stick to the issue.
Yes, okay. I just wanted to comment on this. I'm just trying to get up to speed, and I have done some research. I do have a research background. So I've looked at the history of it all, and I'm going, okay, we have to make a decision here. It's been kicked around for quite a bit. I guess they've been saying it's been going on for 16 years. And just to go on a point-by-point basis, if I may, to everyone, is I'm just going to go from a Souk News Mirror article. And I'm going to use a point form here just to remind everybody here, you're going to be making a really important decision, which is, to me, important to the community. And the point number one is, this is the Mirror article, the proposed bylaw amendments will be part of an OCP review expected to begin next year. The last OCP update was done in 2010. So I've been pondering all of this, and I just want to say, if I was on council or what, but I'm a citizen, for council to arbitrarily amend the official community plan before next year's review, in my opinion, is backsliding, couldn't think of a better word, on the spirit and intent of our community charter. How many people in committees worked on formulating our official community plan? This is what I understand when I've read the official community plan. All of these meetings were held, people that were saying, you know, let's get something here happening. And when I lived here in the 80s, the official community plan was a very profound document. We've always had official community plans in Souk, what have you. Point number 2, the mere article, Mr. Driver's operation has been under close scrutiny by neighbors since he opened 16 years ago, as what started as a small business has gradually grown over time to a small industrial site. Okay, I think you have probably a picture of that. When you see it from Souk Road and what have you, well, okay, it looks
Direct
quite
your
impressive.
comments
I'm
to
sorry.
me, please.
Okay, I'm sorry. I just want to comment on this. So we have here, he asked in 2002 a development variance permit. And it's got here, he wants to add an addition to a barn. That's in 2002. And I'm going, okay. And then I have another a letter here from one of his adjoining neighbors, and this is 2005. Approximately 2.5 years ago, I received a letter from Souk Council stating the new owner at 5536 Souk Road wanted to extend his barn by 20 feet. That was okay. But the new owner did not add 20 feet. He built a new building, 100 feet long, of double corrugated steel. This is a very mysterious building. He goes on, it has no windows, 2 huge truck doors, big trucks come and go, and blah. And then he's got here, now this is the last straw. He's in the process of constructing another building back to back with the steel building. It has a green roof, and it goes on and on with the letter. This is 2005. There's the Development Variance Permit here, so I'm going, okay. And then we can move on to point number 3. The municipality has faced several complaints about the business operating without proper zoning and no business license. Mr. Driver has said he has never received a cease and desist letter, but Corporate Officer Carolyn Machada, said the district sent him a cease and desist letter on February 12, 2004. So I have the letter here, and it says it has come to our attention that you may be using the barn building for commercial welding activities. If so, I ask that you cease and desist this activity immediately. And then Ebony Logan says there's a letter 2007 saying cease and desist, cease and desist. Cease, you know, this should have been handled a long time ago, in my opinion. And then you move on to point number 4, my last point. Last September, Council issued a business license to Driver Enterprises, but it was later revoked. And Driver was asked to submit a rezoning application, which I suppose we're now going into the temporary operating permit, all of that. In reviewing the application, it was found the property did not comply with the official community plan, the gateway residential designation. So there's district staff saying, I'm sure they've met, they've put together 4 proposals to you about what to do. You know, you can choose number 1, number 2, number 3, number 4. I think you just, right now we're deciding on number 4 proposal. And just in closing, I would say, you know, in all due respect, I would oppose that Council waive Policy 9.1 land use activities contrary to the current bylaws and resolutions as it relates to the zoning application, PL. You follow me on that. And just something I just wanted to throw in at the end of this is that I would also move that Councillor Ray and Berger abstain from voting on these bylaw amendments as far as the official community plan, because, well, they've sat on council and now they are basically going to sit this one out, I would say. So I would leave it up to the 5 that are going to be attending to this next year to make the decision. And I'm, in all due respect, okay, it's all done great. And a further, I would move that council instruct the District of Souk staff to send Mr. Driver another cease and desist letter that he closed down his non-conforming business by no later than November 30th, 2018. And I just put November 30th, 2018 in the sense that you got to wind down a business in the sense he has certainly a business happening. And I'm going, well, 60 days to wind it up. Maybe you can decide whether it should be longer, but I thought let's get it done before the Christmas break. Thank you.
Thank you, Mr. Rhodes. Just a few things. Council did already waive that particular policy. We wanted to progress along and find a solution, which is where we are today. I would be disappointed to see Councillor Berger and O'Reilly leave the room. They're still in office. They still have a duty to our community, and I am glad they're here participating. Thank you.
You are going to actually waive the...
We've already done that
policy,
policy, yes.
So you are now going to give them a temporary operating
No, sir.
permit?
No, sir. What we are doing right now is we are determining whether or not we will allow businesses within this particular area of Souk the ability to apply for a temporary use permit. Should Mr. Driver wish to apply for one, that would follow these hearings.
Aha.
So we are
it's
dealing...
It's not about drivers welding.
No, we are
about,
dealing particularly with this area here.
And so would you change the wording of the official community plan to have this go through as far as... Is that...
We would be amending the official community plan.
You would be amending it.
As we've done before.
As you've done before.
Yes.
And I think probably you should probably wait till next year before you even start amending things now. But thank you.
Thank you, Mr. Rhodes.
Hi.
Troy Lebecki, 5697 Souk Road. First of all, I think we need to point out again that this is not directed at one particular address. Nobody seems to get that yet. Bylaws are bylaws. We make amendments to bylaws all the time. Historically, it's done. When the District of Souk is dealing with a business, no in particular business, when they have been doing business with this business for 14 or 15 years, and we have not given out one bylaw infraction ticket to these businesses. And now we're talking about a cease and desist. I do not think that Souk is in the business of shutting businesses down. I support the amendment to this bylaw. I think the 2-year temporary permit or whatever we're doing, it's our only option. We can't just go start shutting businesses down. I mean, when you talk about shutting a business down that's been working in Souk for 20 years or whatever, and somebody actually has the gall to suggest you got 60 days to shut this down, it's completely absurd. So I support the amendment to this bylaw, and I think everybody in this room really needs to get it in their head that this is not directed at one particular address. Thank you.
Thank you, Mr. Lebecki.
Do you want me to restate my name?
Yes.
Derek Noors, 5526 Souk Road. I apologize if you had the impression that I was attacking staff. That was not the case. I just wanted clarity. And I'm going to seek clarity from staff through the chair, if I may. As I recall reading the notice in the paper, the applicant for this OCP amendment, can you please tell me who it is?
I can do that
Okay,
because I have it in front of me. It does say Sean Driver.
Okay, so we're making this OCP amendment because of the applicant, Mr. Driver. This happens to impact up to potentially roughly 900 properties, but the legal posting was Mr. Driver's request and his paying, as I understand. I just want clarity on that.
Can I have clarity on that, please?
Through you, Chair, the applicant was Sean Drivers, originally for a zoning application, an OCP amendment. As head of planning, I determined the zoning amendment did not comply and assessed some other options that might fit and address other issues in this area, and presented them to the applicant, and he was in agreement, had paid for the OCP amendment, so we took it forward.
Thank you. That clarifies it very much. Thank you.
Kevin MacArthur, 6495 Riverstone Drive. So the main contention seems to be how to support legal non-conforming uses. There's a debate about whether or not particular businesses are legal or are not legal. But the amendment that we're talking about is specifically to target non-legal, historic non-conforming businesses. I would ask why this couldn't be worded in such a way that it only allows for legal non-conforming businesses to then regularize into the legal way to do it today through this process, but changing the word from historic non-conforming to legal non-conforming. Then any applicant could then make that argument through some court process by whether or not it is decided this is legal non-conforming or simply non-legal. And then going forward on that basis, it would allow the other businesses that we're presumably talking about on the 900 lots to make the same argument whether or not they pre-existed the zoning, pre-existed the rules. And that then becomes a court process that's just easily sorted out with lawyers. Can that case be made? Can it not be made? And so if we could change this OCP amendment to point to specifically legal non-conforming, then that might solve the problem for everybody.
I don't know that it would, and I'll have staff correct me in this case. When Mr. Driver applied for his business license, council granted it, and it was revoked because he does not have the zoning to match his use. So that's where he started on a process to be rezoned and to be with a zone that would allow the use. Then what was determined was that particular area of the OCP does not allow that zone to exist. So that's why this isn't a rezoning, and this is why the OCP needs to be amended so that had happened. Now, our OCP is out of date. There has been a desire by the community and council to update the OCP, so we know that's happening. So that's why in this case the Path Council has chosen that he would be allowed to apply for a temporary use permit that would allow 2 years, and then in that time the community can update its OCP. Then Mr. Driver would zone, it's up to the community to decide what they want to see in that particular area. Some could argue, why are you going to dump all industrial uses in one particular area, say Kaltassin? We have residents that live there and want to continue living there as well. So that's why this area of Souk is unique with a number of different uses. We have been made aware of other businesses that are operating without zoning. They are not able to zone because the OCP does not allow that zone to exist in that area, and that's why the OCP amendment is coming forward to allow council the ability to issue temporary use permits, because at the moment we cannot issue them in this particular area. So should that pass, then any business owner could then apply for 2 years temporary use while the OCP gets resolved. Then they would come back and apply for zoning. Is that in a nutshell? If I missed anything?
Yes, Your Worship, and I would just add for clarity for the public as well that this would be, if this amendment is approved, and a temporary use permit would come soon thereafter, after a minor zoning bylaw amendment, and if that temporary use permit was issued for a period of time, during the time that it is issued, there would be an OCP amendment. God willing, we get budget, that would take part for a period of time, and there is still a chance, and this has been explained to Mr. Drivers, that through that OCP amendment, if it's determined with the community council and all of the District of Souk citizens that are engaged in that process that this is not the appropriate place for heavier commercial or industrial, then the temporary use permit, once expired, would have to be reassessed. But this is a temporary solution with a potential for a permanent solution in the future, but it will involve all of the citizens of the District of Souk.
Other members of the audience would like to speak tonight? Sorry, Mr. McClyman, can you turn on the microphone?
Dave McClyman, 6110 Kirby Road. I support this process. I think this is a fair way of getting this business still going. It does affect some of my family property too. I'm not too sure how that is going to affect. That part of it is in a mobile home zoning there too, that gateway, so I'm not sure how that would affect that part of Lanning Creek, the zoning. But I use this business. I've used it for quite a while, and my options are very limited in Souk. I would have to go Miller's on Souk River Road, or I would have to go to Langford or Victoria for equipment repair. So I think this would be a solution that would work for myself. Anyway, thank you for the time.
Thank you, Mr. McClyman. Other members of this? Thank you.
Jerry Slepowicz, Francis Road. Drivers Welding not only supports the districts of Souk, but many other residents, including myself, both professionally and personally. I've used them for both, again, equipment repairs, like was just said, as well as vehicle modifications for my own work vehicle as well. As you stated, Mayor, the OCP is most definitely out of touch and out of date with the current growth that Souk has experienced. We look at the houses out on Winfield Road, many side streets off Church Road, as well as Sun River. The OCP is just it's out of date with what was projected. I mean, the OCP would have been adopted in 2010 and would have been drafted starting probably, I'm going to guess, 2008, prior to my even living in Souk. So it's a long time for a big overhaul. Supporting something like this, it's going to bring the OCP in touch with what's going on in today's Souk, not literally almost half a generation ago in Souk. But at this time, I'd also like to mention to Council the address of 6545 Souk Road. The address is currently occupied by a Lita Hair Studio, a commercial business. I'm assuming, and I say this cautiously, that the business is renting the current building there from Ron Fedosenko. I can find two previous council meetings, one on April 27th, 2015, where his current tenant applied for a business license but was subsequently rejected, and again on November 28th, 2016 for a zoning request similar to what is being proposed by Mr. Driver. Mr. Fedosenko had operated that building as a commercial business since before Souk was Souk. He specified the 1940s. He always paid commercial taxes on the property, and only when he decided to allow other businesses to rent out this building did the mistake of years gone by come to light that the property was indeed zoned residential, vice commercial. All of us know it literally sits on the side of the highway. Obviously, Souk was more than likely zoned from a civic roll report of some sort, as it was obviously before the time of Google Earth, otherwise everybody would have seen the obvious error. Now, Mr. Fedosenko did ask that his property either be rezoned or that the town could buy it, as he stated in a redacted letter from November 16th, 2016. However, the minutes from council meeting on April 27th, 2015 state, moved and seconded to direct staff to issue a business license to the current business at 6545 Souk Road without requiring compliance with the Souk zoning bylaw as to the use of the property. Carried unanimously. We can't apply one set of standards on this side of the river and another set of standards on the other side of the river unless the OCP is brought into full compliance, so that the needs of the community, both now and future, are going to be addressed. Thank you.
Thank you. I'll just share one difference is that land has always had a commercial use. It was never residential. So that's where we get into a debate as to what's legal non-conforming.
Ellen Lewis, 5526 Souk Road. Lived there for 30 years. It's interesting what the lawyer said under the LGA 528, lawful use. So it protects you when you make a decision to purchase your land. We purchased our land with a farm next to us, and it was operating as a farm until 2014, at what time, allegedly, because taxes were paid as a farm status. when you purchase land, you make a decision based on what's around you, what the official community plan is. The official community plan was then agricultural. The new one was agricultural, 88, 2001, and 2010. Agricultural. It supported agricultural. There's some comments made about changes coming, and we have to grow with that. When we were contemplating our OCP, when we were doing the work on it, that was part of the plan, was to have the gateway residential, to keep it rural so that it wouldn't impede on the entire Souk Road, that there wouldn't be businesses all along Souk Road, it wouldn't be jammed with a whole lot more driveways. Highway said no more driveways anyway coming onto Souk Road. And the growth was supposed to happen in the village. And this was a residential area, and uses were to be residential with home-based businesses, which are very strict, which comply for residential use. There's a couple of more things. There's so many things. On your page 55, as was stated, Mr. Driver is the applicant. And on page 55, it says, the OCP amendments alone will not legalize existing operations at 5536. So we are talking about 5536. And at the bottom paragraph, it says, it's staff's opinion that through a full review of the OCP, the District Council and Committee would have opportunity to review the gateway residential and properly consider all existing businesses that may not conform to the District's current bylaw and policies. Well, if there were other properties that were concerned, then why was that not the issue? Were those other properties notified? Or people around those properties notified? For instance, if it was, let's say if it was Sunny Shores, it's not, but say if it's Sunny Shores was one of the properties that should be considered as an existing business and doesn't conform to the district's current bylaws, then all the properties around should have been notified about this change. But there is no notice gone out to the 900 properties, and also no notice gone out to people who may be affected by this change. That's wrong. As far as historic uses go, I'd like to say, and Councillor Pearson would know this, that the barns that were there were chicken barns. Prior to that, in 1921, I believe, when Cecinas Land Developments came in there was an orchard planted. There was apples and cherries, and that was an orchard farm. From the 1920s until Essery's purchased that property, there was chicken barns there. Then there was horse riding and boarding. Up until 2014, it was claimed as farm status. Mr. Driver applied for a barn, a permit for a barn, which is now operating as a shop, and soon afterwards was operating as a welding shop. He had a portable or mobile welding business, and it's stated in here different things that he said that he was using it for just equipment that he was using for his mobile welding. Then he was saying that it was a barn, and he's built it under the Farm Act because it's a barn. So what is it that we're dealing with? I'd hate to have somebody like that have a temporary use permit, because I've seen what's degressed over the years. And always, when I'd say, you better check into that, you better stop doing what you're doing. Oh, I'm going to apply for rezoning. Oh, I'm going to apply for rezoning. Well, it never happened. And he just continued doing what he knew to be illegal. And I can't believe that this council is even listening to this as an application, because it's been destructive. The fences have been taken down. There hasn't been farming done on there. One lone cow, moving cows around. I mean, it's a game. But I can't believe that we are even listening to this application to change an entire official community plan when we're going to be reviewing it. And it does change. The temporary use permit will change. People will come out of the woodwork. Well, let's try this temporary. There's already home-based business which covers all those issues. And those ones that are legal non-conforming, they're legal non-conforming because they were in operation prior to 1999. And when Driver applied for a license, for a business license, he misled this council by saying that he had been in business prior to 1999. As we know, he purchased the property in September of 2000, and the barn wasn't built till 2000. He was given a permit a development permit to alter his sight line to 5 meters to the backyard. That was all. No building permit ever issued for an alleged barn. I also have a letter here from Pat Kennedy. It's very brief, but she wanted me to read it out. October 1st, 2018, in regard to rezoning plan, I'm against it. If we keep on going, there will be no residential property left. Pat Kennedy. And that's an issue. We're talking about that about the issue of not having enough housing. We're talking about affordable housing, and here we are taking a beautiful piece of farmland that had all that beautiful soil removed illegally without permit to remove that beautiful soil, and again destroying the OCP, not only the OCP, but the integrity of our community. Thank you.
Thank you, Ms. Lures. Sorry, just turn on the microphone, please. Thank you.
My name is Donna Gray. I live at 5544 Souk Road. I find it interesting that you've mentioned 3 times this is not about one address. And half the people who've got here have spoken continually about one address and one person in particular. Within this climate, I don't know if we're going to find a fair solution to all this. I hope we can. Mr. Driver, since everyone else has been able to mention, I'll mention him too. I happen to live with him, but in this case, I'll call him Mr. Driver just this once. He would like to find a solution. I know you're not going to be able to make everyone happy, but really this OCP amendment is not about him. People would have made the social media and newspaper think it's about him, but it's not about him. It's about much more than him. This situation where he was directed by staff to go before council to get a business license, it was issued to him, and then the city staff revoked it, has brought us to this point. Because up until then, from 2010 to 2017, as the records will show, there were no bylaw infractions against that property. So either the people who are complaining now on force didn't know how to write a letter or an email or pick up the phone, there was no complaints. I find that rather interesting. I don't really have a whole lot to say other than, as a community, we have to move forward and we have to do what's right and fair, not for necessarily one person, but for the community as a whole. And we can speak directly about Sean Driver and his property at that hearing, because I don't think it's really fair to have that brought up time and time again tonight when that's not the issue. Thank you.
Thank you, Ms. Gray.
Hi. Melissa Curtis, 6157 Calvert Road. I just want some clarity, actually, and I know it keeps getting brought up, so I apologize if I'm just not getting it. I really want to understand how we determined legal nonconforming and illegal nonconforming. My understanding is illegal nonconforming is everything before the district incorporated. Is that correct? Illegal nonconforming?
We've changed zoning bylaws over the years, so I'll have staff correct me if I'm wrong. So let's say you have a property that is zoned this, and then the municipality's zoning bylaw changes, and through that change, your zoning changes. But what you're doing on your land remains the same.
Okay.
So now when you look at present day, you would look and say, oh, what you're doing is illegal. It doesn't match the zoning bylaw. So in that case, it would be legal non-conforming. It was legal at one point, it's non-conforming with today's bylaw.
Right, but legal non-conforming then would be after the district incorporated to allow that.
No, it could be, I mean, I'll have staff correct me on this, but the zoning bylaws and OCPs have changed many times since we incorporated. So I wouldn't just say that it's pre or post incorporation is legal or non-legal. I would say it has to do with as different bylaws that govern land use are adopted and amended and changed. Is that correct?
Yes, that's correct, Your Worship. So we did go back to the zoning bylaws that were in place pre-corporation. As I mentioned earlier, those were adopted by the district when they incorporated. So a legally non-conforming use is a use that once had permission to operate as such. And then over time, council would have adopted new bylaws and removed that use. They're now legally non-conforming, or what some people refer to as grandfathered use, and they're allowed to exist as that use until that use stops for a period of 6 months. Once that 6-month marker is passed, that use can no longer occur on that property.
Okay. So this, because we are talking about the applicant, so we are talking about the property, and I'm not doing it to do any type of disrespect in any way, but this is the property we're talking about. Has this property themselves, are they illegal, non-conforming, or are they legal, conforming, non-conforming?
So they are non-conforming, so what you're calling illegal,
illegal non-conforming. Okay. So now my next question is, I see historic non-conforming, which muddies the water a little bit, because what staff has brought forward for a solution includes historic non-conforming. However, when council and staff came in, we actually just had a discussion about not even knowing what that definition was. And yet now you have something in front of you. You had to discuss it on the fly. There's nothing written anywhere. You're now going to make a decision using a historic non-conforming without even knowing what the definition of your own wording is for this. And it just seems, I don't know how it can be done. Yes, if you haven't already have that definition in place, and how that covers over your illegal non-conforming to legal non-conforming. Where does that cover in the gray space? Is there gray space there? Is that what that's covering? I'm trying to get my head around this, and I can't understand how you can move forward and actually make a decision if it's if you haven't even defined these things.
Okay,
that's all I have to say.
Thank you. Are there other members of the public that would like to speak on this?
Gail Hall, 2517 Sucre Road. Just a couple of questions. Is it true, I guess it's the only word I can think of at the moment, that the 900 properties were not given notification of this?
Can we clarify the notification, please?
Thank you, Your Worship. The specific addressed notification did not go out to the individual properties within that land designation. The ads were placed in the newspaper as required by the local government legislation. As there were more than 10 properties owned by more than 10 individuals, individual address notification is not required under the Local Government Act.
Well, it may not be required, but isn't it the thing to do in a situation like this when it's a single person looking for what he wants, and in doing that you've dragged 900 other units in here? And this doesn't seem appropriate to me at all. In fact, if I lived in there, you'd have heard from me long before this. This is not proper. I mean, you've got one person who wants something, and for that, the 900 other people are drawn into this. That's inappropriate. And whoever it was that said we shouldn't be using Mr. Driver's name, I will remind them that he is the applicant, so we're quite free to use his name. And I guess my question is, why is the whole Gateway area drawn into this for one person? Why is it good for Souk?
Through your worship to Mrs. Hall, the application evolved from a specific zone that wouldn't fit within the Gateway Residential. My assessment of Gateway Residential is that there's a number of uses, both conforming and non-conforming, or grandfathered or illegal non-conforming, along that highway that aren't addressed in the Gateway Commercial. And the options in the report that were before council and that are still before council were to either do a full, like refuse the application, do a full gutting of the Gateway Residential, where we go out and amend and discuss with the community from day one what we want to see along that highway area, or to address these non-conforming uses through a temporary use permit until such time as we can garnish enough funds to get a consultant to do the full OCP and not prioritize the Gateway Residential ahead of those other areas. So in my professional opinion, this was a middle ground to address all of those issues.
Wouldn't it have been more appropriate to have a community meeting where some of the rest of the people besides perhaps staff and council decide this? Because it seems to me that we're catering to one individual here, and I don't see from that, or from what I know, which isn't that much, I guess, but I don't see how that whole thing being in the Gateway Residential is going to benefit those folks. Have they been complaining about something up there, or was it just staff and council that decided it was a good idea?
Through your worship, it was my opinion that doing a site-specific amendment would be more inappropriate and show partiality towards one business owner, as opposed to allowing for temporary use permits for historic nonconforming in the Gateway Residential area.
And this isn't for one individual? We all know it is, so it's not hidden, is it? We've done that whole thing for one individual.
Thank you, Ms. Hall. Other speakers this evening?
Good evening, Worship. My name is Luke Poppy. I'm at 7021 Grant Road. We're speaking to Sean Drivers Welding. I've used his operation for up to 10 years. I'm maintenance at Sea Park. We constantly are using his services, and he's very prompt and efficient. I don't want to speak to all the legalities or the wording. All I know is that he is an asset to this community. He has numerous staff, and they're very professional. And there's got to be a way that we can continue his business in this community. And he's not the only business in that Gateway area. So I have used other business in that area as well. So this I know. Thank you.
Thank you, Mr. Poppy. Other speakers this evening? There's a few.
Good evening. Bert Bruel, Valley View Place. I just want to say I'm not in agreement with this. Perhaps the individual in question could move their business somewhere more in a legal place, like we had to do with Arden's in the past. And then these other businesses could access that business still. So I'm not in agreement with this.
Thank you, sir.
Phil Rosner, 2836 Souk River Road. Your Worship, just a general statement. Mr. Driver can obviously have anyone accompany him when making a statement to Mayor and Council, but with that said, I would have a concern with anybody showing up with legal counsel at a public hearing, as I believe it sets up a general sense of confrontation rather than a desire for resolution. And that's especially in light of some of the pointed statements made by Mr. Driver's lawyer. Thank you very much.
Thank you, Mr. Rosner.
Good evening, Matt McKinnon's Snowden Place, 2406 Snowden. I want to speak in support of the OCP amendment because as a resident of Souk, I support fostering these old Souk businesses and keeping employment in Souk. And as a complete community, we need the businesses in Souk. We don't need any more people out on Souk Road, commuting in Victoria, and having jobs in Souk that aren't just fast food and retail is important to have a sustainable, complete community. So I just want to thank Council and staff for finding a solution to this awkward situation to try and solve it and foster businesses here in Souk. Thanks.
Thank you, Mr. McKinnon.
Hi, Shelley Sorensen, 2665 Otter Point Road. However, during 1993 to about 2009, I lived at 2021 Good Ridge Road, which is very close to the one property that we're talking about right now. And I do at no time did we receive any information about this property. This is a property that I knew very well of because I used to actually board my horses there for a short time and use the riding ring. I used to walk my dogs up and down the Galloping Goose all the time and was watching the building of this property and was confused why a property was being built so close to the property line to the Galloping Goose, but it was being allowed. I once actually was just in the district office and asked them about what was being built there, and they said it was a farm building. There's never been an animal in that building except some very big Great Danes. I have horses. You know, I've been in farms. I know what they're all about. I know what a farm building looks like, and it's not. So I think the basis of what happened on this property was not true. At the same time when this was happening and this building was going and Frank Limshew was in the planning, my ex-husband, husband at the time, we approached them about a business on our property, and that was to be a doggy day and boarding kennel. Perfect property, perfect situation for it. Spoke to the neighbors about it because it could be potentially noisy. Looked at what it would cost to soundproof a certain outbuilding to take care of my neighbors. Spoke to all the neighbors, had approval from them. Sat down with Mr. Limshew, discussed our possibilities of the property. He looked into it and said that we didn't have the proper zoning. He told us what we could do to possibly get the correct zoning, what it would cost, what it could potentially cost. And at that time he sat and said, I think it's a great idea, but at this time you don't have the zoning for it. And if you put all this money into it, you probably still will not be able to run this business. So I didn't run the business. Today I look at myself as an idiot. I should have run the business. I'd be making hand over fist right now. I'd be able to work at home right now, which is what I would love to do. And I can't because I followed the law. I followed the advice of our district staff, who I highly respect, by the way. I know you guys do a wonderful job. I'm an idiot. In this case, we've been hearing that Mr. Driver, and I have nothing against Mr. Driver, it's that this is on a piece of property that it shouldn't be on. It doesn't have the correct zoning. It sounds like he's already received 2 cease and desists, and he hasn't followed through. There's questions about whether he has a building permit, whether he has an occupancy permit. Those are kind of things all up in the air because I'm hearing different things from different people. And it's frustrating, and it's confusing, and it's disappointing. And I'm talking about the property of Mr. Driver because after you all had your talk and opened it up, you first opened it up to them, he and his lawyer, before it could be opened up to us, the public. So it is about this property. And if it's what has to do with this particular plan, I think at this point, it's not a good thing for you guys to be voting on or voting for at this point. Because I think you're going to continue to see situations like this over and over again. Maybe it needs more planning. Maybe you need to shelve this for a little while and work out a better solution. I think in the particular situation with Mr. Driver, you're damned if you do and you're damned if you don't. It's either going to cost Mr. Driver a lot or it's going to cost you a lot. That's just the solution. I don't think there's going to be any monetary solutions that's going to make anybody happy. So I think if we're going to lose money as a community of Souk, let's at least do the right thing and show other people that we need to follow through and not have people like me look like idiots because I chose to follow through and I've lost out. It's frustrating. It's disappointing. And I think you guys have to put your foot down. There's a reason why there's an OCP. There's a reason why there are bylaws. Follow through. That's all.
I'm sorry about your disappointment, Ms. Sorensen.
Sorry?
I'm sorry about just that you're feeling that way.
Hello. My name's Alan Hamilton, 6763 Eakin Road. I'm here today to support this amendment. For one thing, Sean does great, Mr. Driver does great work out of that spot. He has skilled tradesmen there which are coming to a dying end, a dying breed. I've seen actual people who build things with their hands. Somehow we've managed to get, I believe we're at 5 cannabis shops in Souk. 3, 4. Either way, cannabis isn't even legal yet, and yet, they've been there for a year. And if council had given them license, that's just a bribe by another name. And as far as any work done on the property, that is one nice-looking business, as opposed to several other ones that we have off of Souk Road that are all out of houses. That doesn't look like professional business. Mr. Driver is cleaning up the yard, put up a nice metal railing, and beautiful sculptures on the property. By now deceased gentleman, but well known. So he is doing nothing but beautifying that area. Yeah, that's all.
Thank you, sir.
Gail Nash, 5496 Croydon Place. I just want to answer a couple of things. Yes, we need businesses in Souk, but we need residential quality. We have that in the Gateway area. We don't want to lose it. We don't need businesses within the residential area. That's what makes parts of Souk so lovely to live in. And I'm not denying that Driver does a good job. I know he does. I also know he does charity. All of that can be done from an appropriate property. There is no reason at all to drag down the community around him with the noise and confusion of a business like that. That spoils their quality of living, and that's what we're trying to get across. And as far as people not complaining, people have complained for years. We just didn't know, obviously, how to do it. I guess we should have stomped our feet and stood at the door and said, this has got to stop now. And like I said last time, I thought when I saw the hodgepodge mess back there that somebody would be coming in there right away to clean it up. I guess I'm dumb. I thought that bylaws were made to be followed, and bylaw officers, who, by the way, have time to come and say, did you know that the front end of your vehicle is over a water place on the road, this kind of thing.
If I can interrupt, please, we're not here to pick on staff.
I know, but I'm just saying that I thought bylaw officers had time to check the most important situations. And to me, degrading a property like that, turning what was a lovely piece of property into an industrial place, which, yes, he's fixing it up now, but what happened to all the years that we all said, gee, it's getting to be more and more of a mess? We still want the residential quality where we can live. We don't want to live in Victoria and come work in Souk. We want to live in Souk and enjoy living in Souk. And I think the neighbors on either side of him especially have that right. Thank you.
Thank you, Ms. Nash. Can I call for any first-time speakers, Mr. Lors? Are there any first-time speakers?
Well, my name is Rick Curtis of 6159 Calvert Road. The one concern I have about this whole temporary permit business that we're talking about until they do a thing that affects these 900 properties is it's too easy to you as council to give a temporary permit and then keep bouncing this ball down the road. I know it's a difficult situation for all of you, but you, not maybe just your council, but former councils have dropped the ball. This should have never been able to develop into what it is now. And Mr. Driver is trying to run a business that started out probably very small, a portable business, and he's grown the business without anyone from councils or former councils addressing this issue as it developed and got bigger and bigger. Now you've got yourself a big headache on your hands and trying to figure out how this industrial property, not commercial property, but industrial property, is working out of an illegal piece of property. And my concern is if you go ahead and give a temporary permit, all you're doing is putting it in place for a while, and then it's too easy for the next council to bounce it down the road again until this is done. And it could take, as much as you want to do it right now, it could take 5 years. Are you guys going to continue to give new permits, temporary permits to Mr. Driver without any form of ability for him maybe to move on to a commercial property and keep his business going? Maybe give him a temporary permit if you so desire, but with the intention of him giving him an opportunity to move into some commercial property and continue his business and grow it. Not allow a piece of property that should have never been allowed to go as large as it has and disturb the actual residential area. So by you people giving a permit, you're basically making it too easy for councils and further councils. Well, 2 years from now, if you gave a 2-year temporary permit, another 2 years and another 2 years. Where does it end? And another piece of property can do the same thing. And then you've got 5 or 6 properties along that corridor all doing the same thing. And then you get yourself a bigger mess. So you don't stop it now and at least have something to fall back on until this is a new plan comes about and done, which could take years, which most stuff does because of all the regulations. And so anyway, that's all I have to say. I just feel it's too easy to give a temporary permit, and then all of a sudden, 2 years down the road, all of a sudden, well, we'll just give another 2-year permit, and that keeps going on. And then another business in the area does the same thing. Pretty soon you got 5 or 6 of them.
I'll just clarify, Mr. Curtis, that what we're looking at today is whether or not council will be able to grant the ability to provide those. We're not necessarily issuing one to any business owner tonight.
I know. I'm just saying, make the comment that.
And I want to clarify that a temporary use permit is for 2 years, and by law can only be extended one time.
Okay. I'm just saying that this will encourage other people to maybe do so, and before you get this plan in place, which at 5 or 6. I know you have a plan to do it as quickly as possible.
But Mr. Curtis, also in terms of the historic use component, it's existing non-conforming business. It doesn't allow new businesses to start up tomorrow or the next day or the next. It would be only what is historic, and that's in this particular area and operating now. It doesn't allow for anyone new to move in, set up, and start operating.
Yeah, I'm just concerned that the business was a small non-conforming business, but it has grown into something that's more industrial. It's not a small commercial mom-and-pop business in a backyard.
I understand.
That's not what it is, and that's what I'm concerned about.
Thank you, Mr. Curtis.
Okay, thank you.
Other speakers? I think I saw some first-time speakers. Hi, I'm Rita Fraboni. I live at number 39, 6947 Grant Road.
I'm in favor of the OCP. I don't even know what to say anymore, other than I'm in favor of it. Since we were talking about drivers and he wanted this thing to go on, I've worked at Drivers since 2012, and I've started my apprenticeship there. We need businesses in Souk for trades, and Sean does that, and other businesses are doing that, and that's what we kind of need. We do lots of work for the school. We've taken work experience students and all that other stuff, so other businesses and stuff like that. The community plan would probably help, and I don't know. Thanks.
Thank you, Ms. Raboni. Do I have other first-time speakers? Mr. Lures, you have the floor. You still need to introduce yourself again, though.
You just called my name. Derek Lures, 5526 Souk Road. If I could ask staff to bring up my PowerPoint, and I'm going to conclude my presentation after 2 questions, if I may. While she's bringing that up, can I, through the chair to staff, can I ask, in her opinion, what type of permit will we issue if there was a temporary use permit to be issued? Will it be commercial, or will it be an industrial that would be the application?
Perhaps staff can answer that.
It will be a temporary use permit for a specific set of uses that are submitted in the application, not a zone.
I understand that, but our actual forms, the application form for our temporary use permits, have checkboxes for either. Thank you very much. For either commercial or industrial, so it's going to be, and under the Local Government Act, we can only issue temporary use permits for either an industrial use or a commercial use. So I'm just looking to see which one would be applicable if we get to that point.
Well, if we want to get into the semantics of it, the uses that are currently on Mr. Driver's site all fit within the C3 zone. So that is a commercial.
And may I, through you, the chair, I'm not going to get into it because I think we address it in this PowerPoint. I'm not going to get into debate. I'd just like to also comment, it's great that all these people that have come in support that use Mr. Driver's services. I don't argue he does good work. I don't wish him ill will in his business ventures. It's great that they all get to use that business. But guess what? We are the people that get to see those people every day coming and going in their trucks and cars and excavators and rollers and compactors and fifth-wheel trucks and so on and so forth, and the clanging of the metal and the welding gas and the grinding and the race engines when that season's upon us. So it's great, and I hope that can continue, but I just would like to see it continue where it actually belongs. So thank you for that part. Now I just got to familiarize myself with this slideshow. All right, hold on. Which is the button? Forward? Oh, okay. I didn't know this was how it's going to work. I've been working on this for a long time, so I haven't been able to. First off, I'd like to apologize for having to read the following, but it was the only way I felt I could cover the points thoroughly. I've done my best to keep to the point. We are here once again. We have a situation that has now been going on for years, and not in front of council like it hasn't been now. It is unfortunate for you all sitting at the table today, but you are the current directors of the Corporation of Souk. The question is, will the next council be talking about how they were left this problem by the previous administration, or will the directors here have the courage to do what is right with integrity and Souk's future? As you all know, or ought to know, the only reason that we're all here and the reason this issue has been dragged on for so long is due to the applicant's misleading statements over the years to both council and staff. The web of deceit has become so large that the current staff and council can't seem to find which way is up. Here's some examples of correspondence from staff. Let me back up. This correspondence refutes comments that were made 2 weeks ago by Mr. Driver when he disagreed with statements I made about permission to use the highway to cross and said that Souk Baco has permission and does it regularly, and he also said that he paid commercial taxes. These documents are in your agenda packages, but I want them to be public to see them. You'll see that the Director and Manager of Ministry of Transportation and Highways refutes Mr. Driver's claims that you cannot shut a highway. You cannot shut a highway without a permit, and he is the one that authorizes permits. It also states very clearly in there that you cannot walk tracked equipment across a highway. That is expressly prohibited and illegal. So again, the information you received 2 weeks ago from the applicant was wrong. On my right side, I guess everybody's right side, you'll see a letter from BC Assessment Authority. Mr. Driver claimed after I did my talk last week or 2 weeks ago that he pays commercial taxes. This email from the BC Assessment Authority explains exactly how it works and that the land is broken into two different components. If it is not zoned, it is assessed at the lower use or the lower rate class, which is residential. So he currently has a reduced assessment value because of the zone that he's in. After that, they have now assessed him in a split rate class, 50% residential and 50% commercial. So he pays half of his taxes in commercial and half of his taxes in residential. And he mentions, and he's provided you guys with documents from 2014 forward that he's been paying commercial taxes, but omits all the taxes prior to that that were all claimed as farm status. I believe the time is now over. You have now had the opportunity to see the facts, not word of mouth, no untruths, but only thing that counts, and that's what is written and what can be proven, as the lawyer said, the evidence. This quagmire is not the doing of the District of Sauk, but of someone who has been very successful for 16 years in abusing the system for personal benefit at the expense of our town. Oops, sorry. And you'll see in here, as an example of what people have talked about before, the Development Variance Permit that was varied the rear yard setback from 15 meters to 5 meters for the addition of a barn, specifically a barn. Sorry, this is a weird system. You will see here in this document by staff that it also, they said, hey, we believe this is something else other than a barn, but the applicant keeps telling us it is a barn. So we now have this issue before us. What are you trying to decide to So now you have this issue before us where you're trying to decide to shred our town's guiding document that impacts about 900 properties so that one person can benefit. It has been said by some that our OCP is dated tonight and why the OCP didn't deal with this property in 2010. To that I say the taxpayers did deal with it. When the OCP was created in 2010, this operation had been working for 8 years under the auspices of a farm. Yet, as a town, we still said we wanted our gateway residential to look like, and did not include at that time temporary or industrial permits in this area, and this was done for a reason. And this property continued to remain illegal. Our OCP has ever once been changed, and now it's out of order, so I have to apologize. Okay, I can't, but it's in your documents anyway. There's only been one time that council has changed the OCP since our OCP was adopted in 2010. There's a list before you in the record there, and the only time it was changed was for a covenant. Now council is looking to provide a benefit to this business and throw out the town's guiding document. So let's assume you decide to ignore the will of the taxpayers and our town's guiding document. What could come next? Well, according to staff, a temporary use permit would be the next step. However, when you look at provincial legislation, you need to understand the history behind temporary permits. The intent of this law is to allow for an application before construction begins. It was created to allow for things like temporary gravel crushing, asphalt batch plants, temporary parking, temporary sales offices, etc., that would not fall under the zoning in place at the time. It has provisions for undertakings and security that should be provided to the municipality to ensure a return to the prior state after the use is finished. So in this case, we are deciding to apply this temporary use permit after the fact for a use that was never temporary in nature. I do understand that the legal opinion is that we can do this, but in my view, this is not ethical. What does the District of Sauk ask for in security? What does returning the land to the previous state look like? Do we do as it is today? Do we leave it like this? Or do we take it back to where it was when it was purchased? Do the buildings have to come down? Does all the blasted rock have to be removed from this once fertile land beside AM Creek? Does all the soil that was removed without permit have to be returned? These are all very important considerations in the issuance of a temporary use permit. You are, by law, supposed to be satisfied that the permit does not adversely affect surrounding properties in terms of pollution, odor, noise, light, traffic, viewscapes, parking, or loading. These are conditions that are impossible to meet, and given the use and proximity to the residents' homes, there's no fence, no buffer, no wall that will stop the noise and traffic from an industrial steel fabricating and welding business that has the vibrations of heavy equipment, diesel engines, and race cars from impacting the surrounding homes. I just want to clarify that short of the picture on the right-hand side, this is not a neighbor spying on a neighbor. These are all taken from the applicant's own website. To complicate matters further, we have an applicant for the past 16 years who hasn't complied with the laws. So as neighboring properties, how can we take any comfort that adherence to conditions that may be set out? In Sook's case, as the head planner pointed out, we'd also have to amend section 3.33 for temporary use permits. So again, another public hearing and more expense. Sook's development application procedure policy 8.4 is also incomplete, and we don't even have a policy for dealing on temporary use permits. Therefore, no process on how to guide staff through this. Let's say that you solve all those problems. What is next? We now have zero guarantee that the OCP will ever change to allow this use in the future, but let's pretend that it did. While the applicant could come to rezone, given everything we know about the current and planned uses, the zones that would likely apply would be Commercial 3, Industrial 2, and most likely Industrial 3, given the unlicensed vehicles on site. So let's look at these zones. The minimum lot size for all of these zones I just mentioned, including the one mentioned by the planner, have a minimum lot size of 1 hectare. This property is 0.86 hectares. So already it does not qualify for getting into this zone. And these zoning sizes are created for a reason. What else do those zones say? The C3 zone says that a machine shop cannot exceed 200 square meters. Again, the applicant's shop is 371 square meters, so again, doesn't fall within the C3 zone. The C3 zone does not allow for more than one licensed vehicle on the property. Only the M3 zone does. The M2 zone specifically prohibits panhandle lots. So that excludes this property. The M2 zone also states that the rear setback is 7.5 meters and the M3 zone is 10 meters. This shop, as you've seen already tonight in many documents, has already a variance of 5.3 meters, and so again, it would never be allowed. The M3 zone also specifically prohibits panhandle lots, and also done for a reason. I have not even touched on the environmentally sensitive nature or the location bordering AM Creek. Nor have I touched on what other uses are permitted in the zone: industrial commercial zones like waste transfer stations, asphalt plant, bulk fuel sales, concrete batch plant, gas station, etc. Are we really okay with all those uses in the future, should this go ahead, beside the Galloping Goose Trail, the AM Creek, which is a salmon-bearing stream that we all had that nice salmon yesterday at the salmon bake, and the AM Creek Park Reserve? So now you have this information that shows that even if you push this to the next steps, there are several lawful roadblocks to preventing this business from becoming legal. Is a town supposed to change all of its laws, have several public hearings, consume more of our staff resources and our taxpayers' time to accommodate one business that has been thumbing its nose at the rules for over a decade and a half? And if I may just get a water. Sorry, thank you. Thank you. Zoning laws are about density, lifestyles, livability, and how we want our community to develop and look like. The lot sizes and setback requirements are determined based on those best practices. Zoning, you must remember, is not a right, but it's a privilege. Upzoning also creates value. If for some unforeseen reason the landowner can find his way around all the requirements for zoning and is processed through this tonight, he has the potential to increase his value. Based on a comparative industrial lot in Souk, an upzone could add between $1 to $1.5 million of value to this property. Again, providing a financial reward to someone who's doing everything the wrong way while costing the District of Souk taxpayers. I've spoken with most of you on council and get the sense that there's a worry about legal liability, and as a consideration around the lack of action taken over time and the issuing and rescinding of a business license. That lack of action has now been proven to be the result of misinformation given to senior staff by the applicant over time. You now have all the documentation before you that explains the applicant had historically claimed it was a farm building and not a commercial business, and because of that, the District of Souk could not take action. In fact, the applicant had farm status and taxes from BC Assessment until 2013, as I previously mentioned, when he was reassessed and split as an industrial residential use. This means that legally, his historic use, if we're going to use that term, of commercial has only been 5 years and not 16 years, as the district has been worried about. There's another document from senior staff who I reached out to this week, who I asked for an explanation why the district never did take action, and this is also in your agenda package. And it's explained in here that they didn't take action because they were continually told it was a farm and that they had no jurisdiction. In these photos here, you'll see the attached business license. It was, for your sake, and I think this is great for you in a legal term, it was not a commercial license that was issued. Maybe this was an oversight or not, but the District of Souk issued an intermunicipal business license. This is done in part as part of a memorandum of understanding with other CRD municipalities to allow for service businesses and industry to work in each other's municipalities, and is completely separate and different from commercial business licenses. The fee reflects that alone, with a $50 fee paid for this license and other businesses in Souk paying $250 for their actual commercial licenses. The district can take pride in the fact that it has not lied, it has not deceived or manipulated anyone in this process. They can take pride in the fact that they acted on good faith, but based on bad faith information that was given to them. Just like the neighboring properties, the District of Souk is the victim here, not the applicant. Are there grounds for a legal case by the applicant against the District of Souk? Perhaps, but I'll be gladly sitting in the court gallery anticipating the cross-examination based on the evidence I've seen before me today. Is there a legal case against the District of Souk by surrounding properties and other third parties should this move forward? I would suggest that's probably the case, and any of those parties that would be cross-examined would have nothing to fear, as they have not been the ones to be doing it the wrong way. It is not likely that the corporation will get out of this with zero mud on its face, but there is an opportunity to be able to wash that mud off, stand up with pride, and say we acted in the interest of law and order, good governance, and protected the natural environment, the watershed, and not to the benefit of one who chose to abuse the system. These are excerpts from our 2010 OCP, which is still a valid document, despite some of the ways that it's been presented. Cecinas is the entrance to Souk and an area appropriately described as gateway residential in our OCP. Our town has continued to state our long-term vision that we value this and we want to create a more organized, environmentally attractive, and aesthetically pleasing entrance to our town. Our vision states that we want to reduce the impact on our natural environment and avoid hazardous land conditions. Is allowing an illegal industrial complex and used car sales and an auto body shop and painting the sales image we want to say when welcome to Souk, where the rainforest meets the sea. In closing, I used an analogy 2 weeks ago about someone who gets a speeding ticket but feels the law doesn't apply to them. Tonight I'm going to try and frame this more clearly for you. The district seems to be of the mindset that it must accommodate the historical lawbreaker in some form or another, not enforce the law or punish the actions for the risk of liability of not taking the action sooner. So I'm going to put this in a context I think we can all appreciate. If someone has been an abusing partner in a relationship for nearly 20 years, and others may think they know what's happening, and they confront the abuser and the abused person, and it's denied and explained as just a misunderstanding, and despite having bought flowers from that abuser store, and the abuser doing volunteer works in the town, and being suspicious, these people never did anything. Until one day, nearly 20 years later, there was actual physical evidence that there in fact was abuse the entire time. Does the abuser get told, well, you know, you've been doing this for a long time and the abused victim is used to it, so it's historic in nature, we're going to make a law to allow you to continue to do what you were doing, in part because we suspected something was wrong and we never took any action to stop it, and we're worried you might take us to court because of it. In Souk's case, we are all victims of this situation, taxpayers, staff, council, and business people alike. And it's time for us to say, enough is enough. With this last meeting for this term, what is Council's legacy going to be? How will history judge you on what is decided tonight? And I would like to close in thanking every one of you for serving for the last 4 years. Thank you.
Thank you, Mr. Lures. Other speakers? Yeah. She's low. Could you please turn on the microphone, and you'll need to reintroduce yourself, please.
Thank you, Your Worship. This is Aurora Faulkner-Killam on behalf of the applicant, Driver Enterprises. I'm going to endeavor to be brief. And in doing so, I don't want to leave council with the impression that my client or myself is accepting of all of the submissions that have been made tonight, but more in recognition of the focused task that you have before you on this OCP. There are a couple of points, however, that must be clarified, and a couple of comments in response to things that are being raised. The first is a general statement about official community plans, and it's important to understand, as I know Your Worship and the councillors do, that those documents are aspirational statements for future uses. When an applicant comes forward and wants to do something new that they weren't previously allowed to do, the official community plan guides new action. It doesn't remove or bind current action in the same way that zoning does. And so an applicant might come forward with something within their existing zoning and not have to seek to amend an official community plan despite an inconsistency. The official community plan comes on top, and the zoning is the site-specific control. And so it's important to have that distinction in mind simply because there's another explanation for all of this, and it's an equally plausible, and in my submission to you, a more plausible one, which is that from the beginning, everyone, including my client and this district, believed that this was a lawful use and went through the steps that were required at the time with respect to these buildings and used them in various ways that were all permitted at the time. One of my concerns that I've seen in submissions tonight, and that I put forward on the basis of an importance in the truth-seeking function. It's all very easy for any of us to look at paper, to hear what is said, and think that we understand what the truth was. You have to be very cautious about listening to statements that are made 10 and 15 years after the fact when they are not necessarily coming from neutral parties. But, and I wish to be clear about this, there's a statement that was attributed to me that I did not make, which is that you have to only look to written documents. And that's absolutely not the case. Evidence comes in many forms, and it comes most directly from the mouths of people who lived it, the people who saw what happened, the people who did it, not what people are discussing or surmising or trying to present in a limited fashion with incomplete documentation from other fora. And so my concern is that you should not be overwhelmed by what appears to be a very passionate, small group of submissions, very focused on controlling an adjacent property. And this goes to the next point I wish to make. Neighbors at law don't actually have the right to control their neighbors' uses, with very specific exceptions. Very defined instances of harm may give rise to some legal right, but the whole purpose of zoning is to define in some ways how land will be used. This property in particular can be used in a variety of ways that are not hobby farms and are not attractive and are not free of noise. And that has always been the case. The district has always recognized that and acknowledged that in how it has handled this situation. And so while it may seem superficially compelling to hear from people who don't exactly like what's going on, those same people don't actually have a direct right to control what their neighbor is doing. Now I'm told, I am advised by my client, that throughout the years he has actually made a variety of farm activities on the property and kept a variety of animals. That's ranged not from a lonely cow but to chickens and pigs and donkeys. That has dwindled over the years. But at various points in time when he applied for that building, that was certainly a use that was real and current, in addition to others, in addition to the home-based business that he ran. I want to point out the significance of a couple of comments that I'm advised are incorrect. One is specific to the size of the property. I believe it was Mr. Lure submitted to council that it was 0.86 hectares. And it's my advice that the property is actually 2.5 acres, which is a hectare. And that's important because that actually drives different uses under the home-based business bylaw. And you can see that I've set some of that out for you in great detail in that written submission that I referred to at pages 4 and 5. We don't have time to go through every line of it. But what I would like to point out to you, which you can see on page 5, is that it actually wasn't until 2006 that the district changed some of the definitions in the home-based business to actually exclude heavy equipment repair and welding and steel manufacturing. Prior to that, there's an arguable case that those uses were permitted. Prior to that, it's unequivocally clear that vehicle and equipment repair was permitted as part of a home-based business. So, notwithstanding the sentiment that has been expressed, it doesn't answer the underlying original source documents that are in play here. I will say that I am concerned by submissions that focus on attributing malice or intent to my client, and I say it's not borne out, and that council should be cautious in allowing itself to be persuaded on what in my business I sometimes refer to casually as the court of public opinion. It's not well informed. And while it is certainly your scope to hear from affected people and their concerns and to note them, it is not to accept holus bolus an interpretation from people who weren't present of communications and exchanges that did not involve them. So in closing, I would simply like to thank Your Worship and Council for the opportunity to address you tonight and reiterate that my client's goal continues to be an outcome that will benefit everyone in the long run. And thank you very much.
Thank you, Ms. Faulkner. Kilman. Calling for comments for we're on a second round now, but first-time speakers are always welcome to come to the microphone.
My name is Mike Wignall. I am not a resident of Souk, but I've been working in Souk since about 1990. My business address is Suite 115, 866 Goldstream Avenue in Langford. I've attended political meetings, council meetings, going back to Lorna Berry, Ed McGregor, Janet Evans, Wendell Milne, yourself. I'm coming here as a neutral guy who's got something coming on, hopefully in a few minutes, but I've watched it and seen the back and forth and the back and forth, and it seems like there's 50 to 75 people in this room that are both right, but they're completely opposed to each other. And I think there's been you guys have a problem. I think Mr. Driver started off a business, and he's been everything I hear, he's a wonderful man and an employer and a great business to have in the community, but it feels like the business has grown beyond its original location. And we've had situations in Langford where that's happened in businesses. When they get successful, sometimes they have to move. And I think by setting up a process, whether it be an existing non-conforming process or you can handle the legalities of it, if you set up a process where you allow Mr. Driver to continue operating where he is, but on a defined time frame and with certain guarantees put in place, maybe there's an opportunity to protect the neighborhood, and that, long term he's going to be moving to a better location in Souk, while not telling him to shut down his business, because he's an employer and he's a needed business in the community. And maybe I'm stating the obvious, maybe it's something that's easier said than done, but I think a consultative process, as long as Mr. Driver recognizes, yeah, long term, it's probably not going to work there. But let's work with, I would suggest to work with him, get what guarantees you need, and support him and encourage him to move to a better location somewhere within Souk that's more industrialized. Thank you.
Thank you, Mr. Wicknell. Other speakers? Okay.
Ellen Lurs, 5526 Souk Road, and I do need a drink of water. Excuse me. This property is not zoned. As you know, the OCP does not support it. If you were to put a temporary use permit onto it, it's not zoned. It still doesn't fit in the OCP. It still doesn't fit in the zoning. You can't put something there that doesn't fit. I'm going to go back a little bit here historically. We bought this property as a farm. We bought our property, and our decision was to raise our sons there. We were homeschooling them and wanted them to be good members in the community. They grew up and both were volunteer firefighters. They were involved in the community and volunteered. I know it's blowing your own horn, but here we go. We're hearing all these good things here. And we've been involved in the community for a long time. They had a petting farm, which when plans changed, OCPs and all that stuff, it wasn't allowed, so we had to shut that down. We also had a garden nursery when we were in the ALR, and because a certain neighbor was upset that we had a garden nursery because she was thinking about doing that, she phoned the Agricultural Land Commission and made our lives hell, and the CRD made our lives hell for a while, quite a while, that we were operating a nursery in agricultural land, which is totally allowed. I just want to say these things because we were doing things properly. Then we had bylaw officers come by saying our dogs are chasing our goats. Another stupid thing. Why would we do that? Also, fisheries coming by, seeing what we did with our manure from our animals because it could be running into the ocean. Well, we did have an official BC license to have a trout pond, and it was inspected every 6 months. So that was another ridiculous thing. But we followed the rules all along. We followed the rules. Also had someone come to check to see if our jams and jellies were tested, to come and see if I had food safe to make pies. Yes, we had those jams and jellies tested. Yes, I had food safe to make the pies. We followed the rules. We worked well within the rules. And even putting up our fence to hide the ugly that we were exposed to on Driver's property, even when the fellow dropped off the wood, Driver had a fit about that because we were building a fence, and we built the fence well within our property line, so as to try to work with our neighbor. When we went to cut down a hazardous tree, which had a huge piece, had fallen off about 30 feet long, which could have landed on his house, and didn't. We let him know that we're going to cut down that tree. Well, it was like all hell broke loose. We would cut down a tree, and then you see what he's done, and we would cut down a tree, one tree, which was a hazard. I just feel that this has just gone on enough. And as far as talking with our neighbor, we've talked with them over and over. The lawyer there was talking about there isn't any, it doesn't just have to be evidence, paper evidence. Well, it isn't paper evidence. We've been in conversation with driver and his wife for years, saying you've got to stop doing this. This is illegal. You've got to apply for rezoning. Stop doing that. You can't have all those cars on that property. You can't have this heavy equipment going by here all the time. The conversations were going on. We tried to deal with our neighbor as a neighbor, talking to our neighbor. It wasn't that it wasn't happening. We were really trying to deal with the situation because I don't think it's good to have bad neighbor relations, and we tried to have good neighbor relations. But obviously, the intent of this person was to destroy their property. He took down the fences, all those fences that keep animals.
Ms. Lurs, we do need to.
I know that. I know, but this has to be dealt with. He took down buildings, threw them onto the Galloping Goose, took our son's transmission, threw it on the Galloping Goose. They're still there. And so he's not compliant. You know, this good citizen is not compliant. He's destroyed the neighborhood. And this is the gateway, where the forest meets the sea, which we keep getting told. This is the gateway to our community. And it's always been that beautiful drive down Souk Road with all the trees on either side, and just that's a breath of fresh air. And that's what makes our community. And it's being destroyed. And I hope you make the right choice. And I also want to close by saying, in your own council procedure bylaw, the following procedures apply to voting at council meetings, and I hope that this is done. When council is ready to vote, the presiding member must put the matter to vote by saying, those in favor, raise your hands, and then opposed, and those opposed, raise your hands. Whenever a vote on a matter is taken, each member present shall signify their vote by raising their hand. I would hope that this happens. I've seen too many times this is going on, and nobody's paying attention. Oh, I don't hear what's being said, and nobody puts their hand up. Or some people don't put their hands up. I would like to see a show of hands, because I will be voting in this election, and so will others. Thank you.
Thank you, Ms. Lurs.
I'm sorry, Melissa Curtis, 6157 Calvert Road, and I know it's getting really late. I just have two things I want to say. First, in regards to a statement that, and I apologize if I don't say exactly what it was, from Ms. Faulkner, indicating that possibly the owner didn't know what the use was when he bought it. I don't know about you. I'm a property owner, and one thing that I can tell you is there's things you check that you know before you buy something that is the biggest purchase of your life. And that is, one of those things is, if you're residential, how you may be able to expand on your property, et cetera, and so forth. I know I'm in residential. I know that I cannot open a commercial business. And if I did attempt to do so, I would know I was in the wrong, and I would know that I was on borrowed time, waiting for that complaint to come forward. Whether or not it really should be up to somebody complaining, because really that's my moral compass, but I'd be waiting for that complaint to come forward. Now, so that's the first thing. But we know when we buy something, a property like that, we know what it is. And if we don't, that's nobody's fault but our own for not doing the due diligence required for that. Secondly, I can have chickens on my property, a few. I don't. But if I did, and I was going to build a coop for them, I'd be building a small, cheap chicken coop. I would not be building an industrial building for my chickens, because it's not practical. Unless I had intent to use that building after the fact, not for chickens, not for cows, not for any of those things, but for something completely different. Thank you.
Thank you, Ms. Curtis.
Gail Hall, 2517 Souk River Road. If I wanted to have everybody up Souk River Road change their property, could I put forward an applicant paper and have you take the whole thing in? In other words, why is one name on this application and yet it covers 900 things? That doesn't make sense to me. The application just doesn't make sense. It's got one person's name on it, and everybody else is dragged into it. I don't think I could change Souk River Road by having an application with my name on it. In fact, I'm darn sure I couldn't.
Thank you, Ms. Hall. Just come up to the microphone if you'd like to speak.
Mick Road, 7885 West Coast Road. Okay, I've learned a lot this evening. I've listened and I've learned. I suppose we're talking about transparency, integrity, clarity. You know, for me, it's what are we talking about? Are we talking about a barn, a garage, a warehouse? You know, I'm just going to go back to the whole idea of, you know, there was 2 cease and desist orders. All right? You know, to me, to use an analogy, baseball, that's 2 strikes. And then there's this regular council report. It was in 2017, October 23rd, from the staff. And there was some points as far as with the property, driver's welding. It says, additionally, home-based business regulations were included in the bylaw, many of which this land use was or would have been in direct violation of. And I'm direct violation of. And then there's another point made from this report in October 2017. The type of business for which this applicant sought a business license, fabrication and welding repairs, automotive repairs, and sales. Now get this please, listen. Has never been a permitted use under the zoning bylaw, and therefore is not deemed, I'll repeat, is not deemed to be lawfully nonconforming. So I'm going, is not deemed to be lawfully nonconforming. I'm going, they could say, therefore, it is deemed to be lawfully nonconforming, but it's not deemed. So I'm just making clarification here. Clarity, transparency, integrity. This is what we're all listening, we're learning about. So listen and learn. So I'm going, there is, for me, that's 4 strikes. You know, you're out. But I'm looking at council and it's sort of like you're seeing balls and you're ready to walk them. You're ready to walk him to first base. And I'm going, no, he's out at the home plate. He was called out a long time ago. Why this is carried on, I don't know. Excuse me from a, official community plan and all. And just another thing I want to make people aware of is, I call it sort of like the Janet Evans era, but, Souk was certainly preoccupied back, say from 2000 up and everything. They were preoccupied with the Prestige Hotel. They were preoccupied with the new sewer system, EPCOR. They were preoccupied with Mariners Village. So, the council was, doing their due, and also the staff. But then when you look over the years, there's staff turnover.
Sir, can we stick to,
yes,
we're sticking
okay,
to
I'm
the zone
just
here.
saying that there has been staff turnover. So the whole thing about, there hasn't been any complaints since 2007 or 8, and I'm kind of going, he's had already 2 cease and desist orders, and now council is preoccupied with this and that, and then the staff itself is revolving, and I suppose these files just sort of fade away, and everybody's just sort of like, it went away, all right, we can carry on. So just in my final summary, for Mr. Driver, you have a lot of support here, and I've heard that you do great work, and I'm going, then consider another location that's properly zoned, and I'm sure all of these people,
direct your comments to me, Mr. Rhodes.
To all of you, their support, they would probably still support you if maybe you would be in Otter Point Industrial, maybe you would be somewhere over Van Isle Marine. They have welding over there where it's permitted, but I'm just saying, wherever you go, I'm sure all the people here that support you would still support you. So I'm going, get your supporters together, get your staff together, and move on. Thank you.
Thank you, Mr. Rhodes.
Tony St. Pierre, 2385 Phillips Road. I'm hearing a lot of the same things repeated. Sorry, a lot of the same themes repeated over and over. Right now, we want our laws upheld. Fine. We don't want people that break the laws to be rewarded. Fine. But at the same time, I think we're forgetting here that Souk actually needs the business and that there's a lot of employees that are going to lose their jobs too. I think that what we have are people that support those jobs continuing, not the activity continuing on that site. I don't think anyone really supports that. I mean, there might be a few. But I think by and large, Derek has made a great argument, not on that site. I think there's a lot of people saying, not on that site. I think even supporters are saying, not on that site. So at this point, I think maybe we should need to look at what's happening next. It's probably not going to be on that site. But if this amendment doesn't go through, what happens then? Do we go directly to a cease and desist? If it's a cease and desist, how long does Mr. Driver have to move his operation? I think these are some of the questions we need to be looking at. Because otherwise you're messing with people's lives. They're going to lose jobs, they're going to lose houses. Thank you very much.
Thank you, Mr. St. Pierre. Do I have other speakers? So I'll call for a third and final time. If there's any speakers. Okay, so I'll now close the public hearing and ask Council for a short 3-minute health break. Thank you.
Hello. Hello.
Derek, can I talk to you after the meeting? Okay, thank you. Hi, Diane.
Yeah, I'm going to be with you. Hey, Derek, we don't have time. Regardless of what's that?
Because now it's going to get comfortable, that's why you're staying. Because to pack everything up now costs
Okay, if we can call your attention back to your seats, please. Can please take your seats. I have to use my gavel now after all these years. Okay. Okay, thank you, everyone. So the public hearing is now officially closed, and this matter now comes back to council. So I just want to let council know that there are options. Now I don't know where I put them. Council has already considered various options from the staff report and has moved first and second, which of course is what brought us to this here today. I'd just like to share that council could consider third reading. Council could also not consider third reading and submit all this to a legal opinion and deal with it at a future council meeting. So that is an option for council to consider. Or, of course, you could rescind this and propose something different. So I just want to lay that out for council to consider. We have wrestled with this for a while, and I think all of us here knew that there is not just in this case, but in others, there's cases where there's businesses that are not in compliance within our community. To that effect, this council supported a resolution that as a district we would no longer do business with those businesses that don't have a valid business license. And that has passed, and we still know that there are other businesses, not just in this area, but around Souk that do not have business licenses, and that's up to them. We came to a point where we wanted to start bringing businesses into compliance. And what does that look like? What does that process look like? It's in the open, it's at an open meeting, and we're looking for a fair process. In this case, the temporary use would provide with conditions, a short opportunity to operate, but also to clean up and comply with conditions that are prescribed at council. I'd like to raise just a few things. There was a comment about another business who opened up that council closed. That business never applied for rezoning. They chose not to apply for rezoning, so they closed. That was an offer that was presented to them. If you want to do this particular business in that area, you must apply for rezone. They chose not to, and they closed the door. That's entirely different than a business that is looking to find a way to comply. There's comments made about the OCP. And yes, it is a prevailing OCP, even though it was adopted in 2010. Significant time, effort went into it. But I look around our community and I think of, okay, we had land in the agricultural land reserve that was, for whatever reason, taken out and developed into a subdivision that has residents living in it now, and we call that place Sun River. There was a vision in the OCP of a place called Artisans Alley, and it was within the town center, and it was to have a collection of art galleries and shops, and it would all be walkable, and that was a vision laid out for our town center that was paved over, and it's now a car wash. Employs local people. It's a good business in Souk. We have residents that have lived to a forest with wildlife and habitat and the like. Now they're living next to a blasted zone and a pile of dust that is now being developed. And it's part of the growth, and it's painful. Growing is painful. We are a young municipality, and we are hitting pain along the way. But through part of that growth, it's How do we grow and how do we mature and how do we find a way forward? In the case of this business or others, they've been in our business. We've procured services on behalf of the community. So yes, there's argument that there's been cease and desist orders along the way, and why isn't council paying attention to this? We've procured services all the way up to 2017, services that were needed within our community. There was a comment made that this particular business lied to us and said that they were doing business before incorporation. Well, they were. They just weren't located in Souk. It's a mobile business, and that's my understanding. In terms of, so that just brings us where we are today. The OCP changed to allow cluster dwellings. Now we hear that there's parking challenges all over town. And why did we allow these things? So we're looking for a fair process here, and I think that's where now council takes this into consideration. And what do we do? There's no certainty on the official community plan. That's up to the community to decide what values are important, what sort of things they would like to see in their neighborhoods. We do hear, we've had businesses come before us, 2 public hearings, trying to get approvals for what they do, the gauntlet of bureaucracy that they have to run, the uncertainty at council. I know that that happens. And at the same time, we're also looking for employment, for local opportunities, skilled trades and the like, and for young people to have opportunities close to home and to rely less on traveling back and forth. So it's an interesting challenge that we have. We're not the only community faced with this. We've spoken to a number of different mayors in other communities. Everyone's struggled with this at one point in time. Some will say, well, why don't you do what they do? And they shut it down. Well, they might have done that 20-some years ago. It's different. We're all going through this, and it's not a problem unique to Souk. I think it's great that we have many concerned about the future of our Souk and how we want it to develop, and we're looking for fairness all the way across. So there's different opportunities now for council, and I'll just leave it for others to speak. And there are, like I said, different options. Give third reading, take all this information that has come in, some of it just even in the hours leading up to the meeting, and to pass it down to a future council to decide or to propose another action. Comments from members of council? Councillor Ray.
Thank you, Your Worship, and just want to thank everybody for coming out and spending the time to speak to the matter. And of course, I want to really thank staff for all the work that they've been putting in. As some of you know, when it comes to difficult decisions, I like to get myself prepared. I don't do really well shooting from the hip when I speak. So some of what I've heard has changed in terms of what I've written, so I'll try and keep it brief because it has been a long night. But I hope that people can then understand how I got where I did. So the District of Souk, and this has been said, incorporated in 1999. In terms of age, one might consider the District of Souk as a fledgling community with growing pains and strains on both staff and councils as they try to get a rhythm in both its bylaws and policies and the ability to develop a vision for Souk. Today was a public hearing on a text amendment to our OCP, which in essence is to deal with a long-standing issue with one particular property, in my view, that is located at 5536 Souk Road, been referred to as the Driver property. Mr. Driver is seeking some relief to continue operating his industrial business on property located in an area known as Gateway Residential, as he requires a business license for insurance purposes, and his use of his property, in the opinion of district staff in 2004, 2008, and 2018, contravenes the zoning bylaw. Mr. Driver purchased the property in September 2000 and was subjected to the zoning of the day, still under the CRD, Agricultural Zone AG. I'm not going to go into the details because I think we've heard it enough. The bylaw, in 2004, the district adopted its own bylaw, 270. It changed in 2010 and again in 2013. I'm not sure, and I don't want to get into that bait, but this is my thinking. I'm not sure how Mr. Driver was under the impression that the zoning ever allowed for the use of welding and steel fabricating as all of the zoning immediately prior to incorporation and after incorporation has always clearly delineated that it was prohibited. In February of 2004, a letter was sent to Mr. Driver by the district's municipal planner of the day telling Mr. Driver to cease and desist his activity immediately, and it also clearly outlined to Mr. Driver what the property was zoned for and drew his attention to the section related to the home occupation. The letter also indicates that bylaw enforcement would be in touch to ensure compliance. So I have to ask myself, how did we get from 2004, where Mr. Driver received a cease and desist letter for the business that he was operating on the property, and I have to ask myself, why didn't he stop the business or apply to the District of Sauk for rezoning? Like, why would you continue to grow a business on property that you have been told doesn't conform to the zoning? Was it just a wait-and-see approach, which I think would be risky, and I think others have actually mentioned that here tonight? And I also have to ask, why was there no enforcement from the district back in 2004 or 2005 or 2006, whenever? Did the enforcement fall off the district's radar? Were there legal issues that I'm not aware of today that there was a barrier for that enforcement? But whatever happened back in those days in 2004 has resulted in a situation that we have today in 2018. A successful business that has virtually flown under the radar. And of course, the district has also purchased services from the business. So, two things. The letter that we have on file shows that Mr. Driver knew in 2004 that he was in contravention of the zoning bylaw. And the second is that there has been no enforcement. I have to think back to some of the matters that I've heard through my 2 terms. Sauk Disposal, a long-time locally owned business, bought property along Sauk River Road, contiguous to a property zoned industrial, where they had previously been doing business. They came to council to get a letter of support to have the property brought out of the ALR so that they could continue with their business. The council did not support the removal. Council was not supporting a business on Idlemore operating as a transfer station because they did not have the correct zoning. They chose not to apply for a rezoning. In 2015, this council ordered a local resident to remove all of the cedar trees on his residential property because it was in contravention of the bylaws. I also think to the owner of Pure Elements, who went through a humongous number of hoops to try and get what was needed. So do I support what is being proposed by staff, which will in fact allow Mr. Driver to continue with his business? A thriving business, there's no doubt. People use the business, people like the business. But for another 2 years, does that allow other businesses in the Gateway Residential doing the same that are also flying under the radar? But what about the businesses in our community that have played by the rules? Do I say to them, well, it's better to beg forgiveness than to ask for permission? What message does that send to our community about our bylaws and the selective manner enforcement? Where's the fairness? I think it's imperative that people who look to sit at the council table have the ability to hold people and businesses to task to ensure that the bylaws of the District of Sauk are applied equally and fairly and enforced when not followed. Otherwise, the optics are of favoritism and allegiance to those who you know or have similar interests to. It has been more than 14 years since Mr. Driver received his letter to cease and desist, and he was in contravention. It is now before this council to consider an interim solution to what I think is like trying to fit a square peg into a round hole. While I sympathize with Mr. Driver's situation, he was well aware that he was in contravention of the zoning bylaw in 2004, and in my opinion, he decided to take a risk. I'm here at this table because the people in Sauk entrusted me to ensure that I did what was in the best interest of the community as a whole. I think it's time that the District of Sauk moves into a new phase of being proactive in ensuring there is in compliance with zoning rather than reactive. Waiting on complaints will only be the bane of future councils. Like, this will not stop. This will continue to go from council to council. I cannot support the temporary permit text amendments as I think it will only exacerbate the matter and continues to allow commercial operations not in compliance in the Gateway Residential to be operating with an advantage over other commercial businesses that are playing by the rules in the District of Souk. There cannot be selective enforcement. There needs to be fairness and equity for all moving forward. And the fairness comes in governance. And to ensure a level playing field for both our current businesses and future businesses to come. So I will not be supporting the motion, the third reading tonight, as it reads.
Thank you, Councillor Ray. Councillor Parkinson.
Through your worship. And I would like to echo Councillor Ray's sentiments on this. I am truly sorry that the notice of the public hearing actually stated the applicant's name, Sean Driver, and what the district has done by this is basically pit neighbors against each other. For me, this is about one property now, and I'm sorry to say that the hearing turned out the way that it has. I cannot in good conscience vote in favor of this OCP amendment. The scope of this amendment is far too large in scope, as it includes all the lands between Roche Cove and basically the Souk Bridge. It is basically half our town that is included in this, and I cannot agree with that. Thank you.
Other members of council? Councillor Loggins.
I'll keep it brief. I just want to say I completely echo Councillor Ray's statements. It's pretty much what I have written, but more eloquently said, so I'll leave it at that.
Thank you, Councillor Loggins. Other councillors? Councillor Pearson.
I have quite a bit written, but the historical view is in front of us, and it's, the last council meeting of the last hour, the 11th hour, and we all know the challenges of making the right decision at the right time. So we can't change the history on this thing, and there's been a lot of mistakes, both sides, that we can't. So any decision that we make tonight has to be corrective in nature, not punitive in nature. I heard from members of the public who are concerned about the well-being of our economy and things that are important to all of us. There's neighbor versus neighbor, and in an application, there's some value in having a temporary use permit that comes before council on an individual application basis throughout the zone, because I think that was one of the solutions. We had an enormous amount of legal information dumped on us just before this meeting as well, that I haven't even had time to even digest, and I get everybody's making, assumptions that everything is very straightforward and black and white. There's a lot of history that's mixed into this, that we may or may not even have the nuances of that history. We see it now. We're at a decision-making point. There's former councillors that are making letters of recommendation or support in the package that we have. There's multiple times of government and employees who have made, I think, bad decisions. I think there's been bad information come from the use of this property. So it's difficult to make a decision that is ripping the Band-Aid off completely without any kind of consideration for a transition period. I think that through no fault of his own, in opinion, Mr. Driver's gone along. I echo what the mayor said earlier, that he's gone along and he's created employment and he's done a lot of these things. But I heard one of the members of the public say something that reminded me, is that there has to be some form of transition. What does that transition look like to us here? It doesn't look like there's a win for anybody in this. Again, our decision has to be corrective. We're a big municipality now. We're going to be 15,000 people anytime soon. So that puts us into a different category of we're growing up. So when we grow up, that means we have to abide by the rules and regulations. We're a rural community that's transitioned now into an urban community. And that transition brings with it a lot of historical wrongs. Deals were made, wink, nod, to just go ahead, do these things, and it continued out through our history. But I think now it's time that we have to start growing up, applying the rules and regulations, and acknowledging what our history has been. So how do we fairly do that? I'm not sure that all these solutions have the perfect answer. So for me personally, I would support a text amendment to the OCP for a temporary use permit. And the reason I want to say that I want to support that is because I think it's fair to someone who's been around for that long, needs a transition period. But the terms and conditions of that temporary use permit have to be clearly stated. I asked a lot of questions earlier about 219 covenants and how could we control that? Because, you know, paying fair share of taxes, doing the right thing next to a riparian stream, doing the right thing on property has all got to be part of the decision. If we turn down the text amendment, that's so be it. But what about the transition period for employees and people that are in our community? Difficult decision. Last night of a 4-year term, and probably the most robust discussion that we've had to date. I'm impressed that this many people have been here for this long. And I'm impressed with the way that people have come together in the community to support one way or the other. And we're sitting here now charged with this. 18 days before an election, kind of a tough night for us sitting here. Anyway, we're paid to do it, so we'll do it.
Thank you, Councillor Pearson. Councillor Berger?
Yes, thank you. I agree with most comments that have been said tonight, but for me, the entire topic, if we make it isolated to one, it's conflicting. So I'm going to go back to the purpose of today's public hearing is to amend the OCP to allow the temporary use permit in the entire gateway designation area. Our current OCP designations have caused us concern in the past. The lands across from Cecinos Elementary School, since I can remember in my 42 years of being in Souk, have always been industrial. Yet our OCP has them designated as community residential. In 40 years, I haven't seen a house on those top lands that are industrial. A community vision and growth they're forever evolving. Our OCP is supposed to be fluid and it's supposed to be live, and we're supposed to be renewing it. We haven't done that in almost 9 years. I don't support remaining stagnant. I welcome growth. I welcome new opportunities in both housing and commercial. And as you can see by our large binders, we have a ton of information in front of us. I'm not interested in going down the road of pointing fingers, nor am I interested in placing blame, as I think it could fall on many shoulders. As stated by our head planner, and respecting the legal advice that staff have received going forward, I support the staff recommendation to afford all of the residents and businesses in the OCP designated as gateway residential the opportunity to apply for a permit. To reiterate Ms. Campbell's previous statement at the beginning of the meeting, every applicant that applies for a temporary use permit will have to go through another public process. They'll have to conform to whatever restrictions and regulations are put on by the council of the day. And these restrictions could be hours of operation. They could be environmental remedies. They could be buffer zones. They could be noise that can emit to other properties. If and when Mr. Driver chooses to apply for a temporary use permit, everyone can then come back again and a decision can be made that's isolated to Mr. Driver's property, as tonight is about the gateway residential zone.
Thank you, Councillor Berger. Remarks, Councillor Casper?
Some may view that I perhaps speak too much. I'm going to make my comments very brief. I looked to staff for some guidance on this at the last meeting when this whole issue was discussed. I made the motion to have a site-specific application. That was not supported. After saying that, I think it's important, though, that we actually harness some tools that are available by the district and a future council to actually have some very strict, I won't say guidelines, but enforcement aspects as to what should and shouldn't happen with this particular property if this motion passes, or if third reading passes. After saying that, this is a no-win situation. I've never worried about my political skin and what happens because there's an election. I've always felt that if you're going to make a decision, you base it on what you deem is in the public interest. One of the things that I don't want to see this community go through is a long, protracted court case that could cost thousands upon thousands of dollars. And it's not an issue that I would want any council to wrestle with, because the legal steps that would have to be taken to stop this operation, as some advocate, are lengthy, time-consuming, and expensive. And is that in the public interest in the long run? I don't think there's any benefit or gain. But if there is changes, and if this third reading passes, there is a second step where an applicant, whether it's Mr. Driver or any other person, as the staff outlined, meet the qualifications and the category, can apply. And then again, there is going to be public input and public decision-making in an open process. And I'm going to look back at the history, and I'm not going to point fingers, but I will say this, as a member of 3 councils, going back to 2005, not once did this particular property come to a council table. It was never brought forward by any staff member. It was never brought forward for any public discussion by any elected officials going back to my time on this council. And I think that speaks volumes, because it shows, for whatever reason, someone somewhere felt that it wasn't a large enough issue to bring forward to council to actually make a decision to take a legal remedy and action. So I'm going to support third reading, because I want to see this community move on, and I want to make sure that the activities that do occur are on a temporary basis until future deliberations occur in regard to the community plan. And in the interim, that there's very stringent conditions attached to whatever those uses shall be. Right now, we don't have that. And that's been proven by the inactivity for a number of years. Thank you.
Okay. Thank you, members of council. I appreciate everyone's focus and hard work on this until the very end. And we don't have a motion on the floor at this time. There's a motion by Councillor Berger to move third reading, as it's stated. Is there a seconder? Seconded by Councillor Casper. Ms. Machada, did you have a comment?
I was just going to suggest, if council is interested in including a definition of historical nonconforming, I have drafted one that council could include with third reading to amend the bylaw to include
Could
that.
you read that out, please?
Certainly. It would be item D, in addition to the bylaw you have in front of you, that Appendix 3, definition of terms, be amended by adding the following definition in the appropriate alphabetical order. Historical nonconforming means a non-conforming use that has continuously operated on the same property since January 1st, 2010 or earlier, or such date that council determines would equal historical.
Okay. Okay, so we could add that. Is the mover and the seconder comfortable with that being added into the bylaw? I think that clarifies the definition on that matter. So we have a motion on the floor. I realize that this still does not provide certainty to anyone. I know that the neighbors are going to live next to disruption. The business itself or businesses in this particular area don't have future certainty because there is a process. You still must apply for and receive a temporary use permit at a future date. It does provide us, though, with an opportunity to bring businesses into compliance, and what does cleanup and compliance and look like, and what the community wants to see. The OCP does need to be redone. We've had many of us now say some comments as to where it falls out of sync with a growing dynamic community like Souk, and it provides that opportunity for the community to weigh in and to see how these uses find their home in our community. So I too will be supporting the motion that's on the floor. Are there any other comments? Councillor Berger?
No, sorry, I just have maybe through you to staff. I would like to add a time frame. Would that be best approached as a secondary motion?
To apply for a temporary use?
Mm-hmm.
Yeah, I wouldn't confuse that with the bylaw amendment because we're just dealing with the text amendment.
Thank you.
Deal with that separately. Okay, any other comments on the motion? All those in favor? Opposed? Councillor Loggins, Parkinson, and Ray are opposed, and the motion carries. Actually, the motion fails. Pardon me? It carries.
Yes. Council.
Okay, so I'm sorry, I'm really bad at lip singing, obviously.
Council can also consider final.
Okay, so council can also consider final reading of this. Moved by Councillor Berger and seconded by Councillor Ray. Any discussion on final adoption? All those in favor? Opposed? Councillor Ray, Parkinson, and Loggins are opposed. The motion carries. And so now in terms of the time period for businesses to apply for the temporary use permit, I'd like some guidance from staff on that.
I suppose council could put an additional time frame on this, but the letter that's been provided to Mr. Driver has required him to go through a process to bring his property into compliance, and they were already, there's an expectation that that would continue to resolve as he's required to bring all of the issues into compliance, the building permit, the business license, and he can't do that without applying for the temporary use permit. So I think as long as we're seeing some activity move forward towards this continued compliance, I think staff would be satisfied with that, and we could bring it back to council if there was an activity on the application.
Okay. Councillor Casper?
Yes, just for some clarity for the public and I think for a future council, through you, could staff get some advice as to when they would envision an amendment to the zoning bylaw, which was previously mentioned?
I'll start working on that right away.
Okay. Okay, so in the agenda, we are at item 13.3, the Parks and Trails Master Plan. Oh, pardon me.
No, there's a DVP first.
Oh, pardon me.
13.2.
13.2.
Is the alarm going to go off?
Not up here. Does the alarm go off? It doesn't go off in chambers, does it?
It will. He's saying it will. She's saying it's not.
I would like council, excuse me folks, we still have a meeting to get through here. I would like council to pass a motion to extend our meeting time past 11 so we can get through here. Moved by Councillor Casper, seconded by Councillor Pearson. All those in favor? Opposed? That's unanimous. Thank you. 13.2, we have a development variance permit for 5158 Souk Road.
Is this the property where there was a fire? Okay.
Thank you. Go ahead.
Thank you, Your Worship.
Can you change the slide?
There's only 3. So the applicant is applying for a development variance permit to reduce the front lot line setback in the rural residential RU4 zone by 3.3 meters at 5158 Souk Road. I've highlighted the house in orange in front of you, and then I'm not sure if you can see it, but there is a dotted red line and a bit of a solid red line. That's indicating the riparian area setback in the present natural boundary. And I also highlighted the proposed variance and the embankment behind the house. This is because there are several site constraints that influence the siting of the residential dwelling and thus the need for the setback variance. The first is the steep embankment on the north side of the property. The dwelling is located right at the bottom of the bank. The second constraint is the 30-meter riparian area regulation setback. This is measured from the present natural boundary on the east side of the property, and the dwelling is sited in such a way to avoid encroaching on that setback. Any structures that are located within 4.5 meters of the MOTI right-of-way on Highway 14 require a setback permit from MOTI, which was received by the applicant on September 14th. That same day, they also received a controlled access highway permit. Staff supports this variance because it's so constrained on the site for the residential dwelling, and they have gotten every approval that is required from external sources. Thank you.
Okay, thank you very much for that report, and I appreciate you also just clarifying the embankment and the topography, because I think that's very important in this matter. Councillor Loggins.
I'd like to move the recommended motion.
Okay, that's been moved and seconded to authorize the issuance of the development variance permit. I'm too tired to read it out. It's on the screen and nothing's changing. Questions? Councillor Pearson?
Yes, through the chair to our planner. Just seems like that manufactured home has been sitting there for an awful long time. Has it been held up by some kind of variance permit or something? Like, it just seems like it's a long, long time.
It has been there for a long time, through your worship to Councillor Pearson. This didn't come to planning's attention until recently. The applicant, understanding what she needed to do, has applied for everything accordingly, gotten every permit that she needed, and that's why we're addressing this today.
Okay, perfect. Thank you.
Anything else from members of council? Okay, seeing none, all those in favor? Any opposed? It's carried unanimously. Thank you. 13.3 is our Parks and Trails Master Plan.
Thank you, Your Worship. Staff is recommending that Urban Systems be selected as a successful proponent under the request for proposal to develop our future Parks and Trails Master Plan 2019. And as you can see by the recommendations, that we're also asking that the monies be transferred from the accounts as previously discussed in council. The District of Souk posted a request for the proposals in August to retain a consultant to develop the 2019 Parks and Trails Master Plan. This work will result in the creation of a comprehensive Parks and Trails Master Plan to assist with the capital planning, grant applications, future projects, and prepare future population and parks and trails growth. On June 25th, 2018, Council gave direction to proceed with the Parks and Trails Master Plan with the approval to allocate $35,000 from the community washroom budget and $25,000 from the Whiff and Spit study budget. And I'd like to stop there right now and just ask our Director of Finance / CAO if I have the right accounting there, because I know at previous council it came out sort of the other way around. And I just want to confirm that those are the correct amounts from the correct budgets.
To Your Worship, I believe the original request from staff was $50,000. And somehow it ended up different through what was presented by staff and what finally got resolved and into the minutes. But I believe these amounts all take care of that. So.
Okay. Thank you, Your Worship. I'll just continue. The staff posted a request for the proposals for the Parks and Trails Master Plan in August 2018. 4 firms submitted proposals and were relatively close in prices. You can see on the report, Urban Systems came at $74,766. Lees and Associates came in at $71,318.25. Lanark, $71,370. And I'm not even sure how to pronounce that last one. Corvade, $70,000. The 4 high-quality proposals were evaluated based on project understanding and approach, quality and experience of the team, and proposed project delivery. Urban Systems bid at $74,766 was the clear project delivery, with a clear project delivery in integration with the successful proponent of the TMP, the Transportation Master Plan. The proposal outlined a public consultation process which exceeded the minimum in the RFP, provided a science-based approach for information collection from the public and stakeholders, and offered a benchmarking exercise to ensure that we were keeping pace with other comparable communities in the region. Staff are recommending Urban Systems be selected for having a diverse, experienced team, a well-thought-out stakeholder and public consultation process, and a proposal that illustrates similar scale projects having been completed by the firm. Staff evaluated all the inbound tenders, and we found that when we were tabulating the results that we wanted, that Urban Systems certainly came in higher than the rest of them. And I move our recommendation. Thank you.
Okay, thank you, Mr. Howard. If I may just clarify that these funds are from the 2018 budget, correct? Like where we had allocated them initially to these studies, and then when we decided that this was a priority, it's existing this year, right?
That's correct, Your
Okay.
Worship. The work is likely, the bulk of it probably going to take place in 2019. They're going to get started in 2018.
Okay.
So we have to have the funds set aside in 2018, and they'll carry over into the new budget.
Okay, got it. Thank you. Any questions from members of council? So we have a recommendation here, and that's council approve Urban Systems as a successful proponent on the request for proposals to develop a Parks and Trails Master Plan 2019. Moved by Councillor Parkinson and seconded by Councillor Pearson. Any discussion on the motion? See none. All those in favor? Opposed? It's carried unanimously. Thank you. Next item is the Transportation Master Plan.
Excuse me, Your Worship. Oh. There's actually 4 parts to the motion.
Oh, pardon me.
Part 2's on the screen.
Can we move them in a block? Let's move them in a block. Moved by Councillor Loggins and seconded by Councillor Ray. There's no changes to the language, so any discussion? We'll call the question. All those in favor? Opposed? Motion's carried. Thank you for that. 13.4, Transportation Master Plan.
Good evening, Your Worship. Similar to the Parks and Trails Master Plan, staff advertised a 3.5-week RFP for the 2019 Transportation Master Plan. The RFP followed a 2-envelope system with technical proposals evaluated by staff for the same 4 criteria. Staff unanimously chose Urban Systems as a successful proponent. Only 2 proponents or proposals were strong enough to warrant opening the fee schedules, and both fee schedules came in hovering around $95,000. So staff recommends awarding the consulting contract to Urban Systems in the amount of $95,000, $95,190 plus GST.
Okay, questions for Mr. Derrick? Move the recommendation then by Councillor Parkinson and seconded by Councillor Berger. Councillor Pearson?
Didn't we just allow only 50K for this? What was our last motion?
Through Your Worship, it was $100,000. We took $50,000 from DCC funds, and
it was an additional $50,000. Okay, thank you.
Okay. Comment, Councillor Ray?
Yes, Your Worship. I just find that a lot of money for a plan, but understand that that was what we got, so I'll support it. That's a lot of money.
Yes, thank you. Councillor Berger?
Yes, thank you. I agree. And when I first read it, I thought the same thing. But then I thought back to one of our land use and development meetings, and the Transportation Master Plan is actually sort of your basis of getting your OCP going. So it takes a lot of funds out of what we would put in the OCP by having this transportation master plan, because it creates all the corridors and connectors, so it sort of lays the foundation.
Okay, and Mr. Derrick, you'll be involved in this, I hope?
Yes, absolutely, Your Worship. I'll be the general project manager, I guess, but I'll be, seeking guidance from both Ivy and then Paul Butterfield, our other engineering technologist with a lot of experience in traffic engineering.
Okay, I just wanted to thank you for all your work on our road rehabilitation and the like, so I'm glad that you're connected in with this.
Thank you.
Ms. Machado?
Thank you, Your Worship. I just wanted to clarify, it's not going to decrease the anticipated costs of the OCP, but it ties in and is kind of a required work to make sure that we get a fulsome review of our OCP at that time.
Mr. Blackhall?
Yep, just to add to that, Your Worship, also for the DCC bylaw review that
Yep.
we want to do.
Yeah, exactly. Okay, great. And this just ties in. We'll get more knowledge from the province on Highway 14, and then, of course, Transit's doing their surveys and like right now, which is very important. So it's good timing to have all of these essential documents woven together. So I'll call the question. Then we moved and seconded this, right? Okay. Call a question. Or question? Nope. Okay. All those in favor? Opposed? That's carried unanimously. Thank you. 13.5, Aranan Latecomers fees, please.
Yes, thank you, Your Worship. This matter's coming forward to Council. It should have really come forward, I think, years ago. For some reason, it hasn't. Aranan Estates was required by our wastewater consulting engineers to upsize the gravity main down West Coast Road from the development to almost opposite where the wastewater plant entrance is. And due to that, it's basically us telling them they need to build more than what they otherwise need to accommodate future growth in what was then considered the West catchment area. And it's slightly changed since that time due to rezonings that have taken place. So this is bringing that forward to, we can't, unfortunately, retroactively correct this, but the latecomers, per the legislation, the agreements can only continue for 15 years from the completion date of the services being installed. So that would take this one, the service end date then would be, the latecomers end date would be 2024. So there's still at least a period of time that latecomers fees could be recovered. So that's the report. There's the attachments of the previous staff report from 2013 that never made it onto a council agenda for some reason, unknown reason. And then also a draft contract that we will update, of course, and a map of the catchment area as well. And we'll have to, of course, contact every property owner in that area. So.
Okay, moving the recommendation by Councillor Ray. Is there a seconder? Seconded by Councillor Pearson. Any comments, Councillor Pearson?
Yes, through Your Worship, to our CAO. Thank you for bringing this forward. I know it's sort of been sitting out there. I just have some specific questions around anyone that fed down that Grant Road line and into that increased pipeline. So now, because that's a large number of lots, so now that won't be part of the...
Through Your Worship, unfortunately we can't go back retroactively. So people that have taken advantage of that extended service, yeah.
So what would be the liability going forward from a liability point of view from Aranan Estates if it's been our error because this should have been in place since then? Are we incurring any liability?
Through Your Worship, the total amount of the fees that could be recovered would be $122,751, as in the report. If that all got recovered in between now and 2024, which I don't think it obviously will, but that would, I think, be the exposure.
Okay, thank you.
Councillor Parkinson?
Through Your Worship, I understood that the engineer from Aranan would be here to speak to this issue. It's back there. He's right back there.
Okay.
May he come
Is council willing to hear from the engineer on this matter? Okay, sir, if you could please come forward. No, we did call out for the public question and comment. We did. Thank you. Okay. Go ahead, sir. Could you turn on your microphone and just... Thank you, sir.
Mike Wignall, Suite 115, 866 Goldstream Avenue in Langford. I think Mr. Blackhall has covered it succinctly. We've just recently taken over the project as the consulting engineer. It was previously associated, First Team Engineering that became associated. And with the turnover of staff there, Mr. Butler moved the project to me. I've known Mr. Butler for about 30 years. But the original correspondence, I think, goes back to 2009 from Stuart Parkinson at First Team Engineering of the day, and then it sort of stumbled, and then there's another request, I think, in 2016 for an update. And, as you've said, I don't think we can really sort of go back over old ground. I corresponded with Mr. Butler today and said, I think the legislation's pretty tight that you got to set the clock at the completion of the works. And the other development, which my company is also involved with, seems to have slipped out the barn door through the passage of time. And I think it's one of those things. And I asked Mr. Butler if he wanted me to ask that this be tabled tonight to entail further discussion, and he said, no, let's just go through with it. So that's his intent.
Thank you for staying with us and for those comments. I appreciate that, and also just it's good to see this come forward and be dealt with. Yeah. We're trying to get things underway. Councillor Ray.
Yes, thank you, Your Worship. I just want to acknowledge from the comments that Mr. Wignall has made that Mr. Butler, in the essence of getting this to move forward, I just want to thank him, because I think that $122,000, given what he's done in this community, shouldn't go unnoticed or unacknowledged. It's a lot of money.
Yes, thank you. Anything else? Okay, call the question. All those in favor? Opposed? That's carried unanimously. That brings us to, we've dealt with that. Correspondence.
Sorry. Point of order. 14.1 is the presentation of the mayor's medallion.
I didn't see that.
Yeah. Okay, so, Your Worship, I'd like to present you with your medallion, which recognizes your role as mayor and your service to the District of Sauk. And I just want to say it's been a pleasure working with you, and thank you so much. And well done.
Thank you. Thank you very much. I really appreciate that. And just to echo what Councillor Casper said, I would like to thank everyone here for their service to our community. It's been a very long journey. It's gone by fast, though. I'd truly like to acknowledge staff for all of your efforts, all your patience, your hard work, answering our questions, putting up with my quirky behavior, and it's been a true honor and a privilege, actually. For Councillor Ray and Councillor Berger, I wish you most success as you design your life any way you wish and have your Monday nights back. And to all of us that are running for re-election, I would say good luck. It may seem self-serving or even insincere, so perhaps I'll just say best to all of you. I'm very grateful to know you and to have served alongside you, and I really want to acknowledge Council for really focusing on the matters at the table to the very end, last hour of our term. But thank you very much for that. And I think that's something that we should all be very proud of and take note of. So thank you. Correspondence. We have correspondence you received from September 18th to 26th.
Oh, Jay, please.
Pull item J for discussion. Are there any other items? Are you joking or no? Okay, so item J has been removed for discussion. Are there any other items? So I'll look for a motion to receive and file the rest of the correspondence. Moved by Councillor Parkinson and seconded by Councillor Ray. All those in favor? Opposed? It's carried unanimously. Item J, Councillor Parkinson.
So the reason, through your worship, the reason for this one is that I spoke with a gentleman the other day, and he was speaking about the abandoned gases in buildings and stuff, and he suggested that council that the district could actually get a device where you go into the homes and you can see where it all is, where all the gases are. And so he suggested that we might want to look into getting one. So that's why I brought it forward. There you go.
Okay, thank you. So thank you for that. And a motion to receive and file that correspondence. Moved by Councillor Berger, seconded by Councillor Loggins. All those in favor? Opposed? Motion's carried. CAO verbal report. Mr. Blackhall, the mic is yours.
Thank you, Your Worship. I just wanted to thank staff in particular for it's been a crazy busy time for everybody, and just keeping up with all the paperwork has been quite a challenge, and still managed to get the regular work done, which I'm totally impressed by. So thank you to Carolyn in particular, and Ms. Mushenda, our corporate officer, and her staff, because it's particularly very taxing on them at this time of year with all the requests from people that are running for council. We all love you guys, of course, but there's a lot of extra work that goes on this time of year. So thanks to everybody. And I just wanted to update, I attended the Intermunicipal Advisory Committee on Disability Issues, and that was in Colwood a couple of weeks ago, and I spoke about our Rick Hansen Foundation certification that we got for the buildings and the grants that's opened up for us. And it was a really good committee, and I'll probably be attending those in the future. So that was that. Thank you.
Thank you, Mr. Blackhall, and many thanks to you for stepping up and filling in the role, and to all the staff that have supported you and everyone else in the office. Okay, council verbal reports. Councillor Berger.
Yes, thank you. Just a really quick one. I know there's not a lot of people here, but my last CPark meeting was actually very exciting. We saw the renderings for the new expansion. So initially, CPark looked at building the fitness facility at the rear of the facility, and now we've moved it to the front. So the entire face of CPark will get a facelift, which is fantastic. And it's a really exciting design that they have proposed with a lot of West Coast themes. And so nothing's been locked down completely, but that's the first renderings that we saw. So it's very exciting to have that underway.
Thank you, Councillor Berger. Councillor Ray, then Casper.
Oh, I was just going to say good night, Sook.
Aw, last time with the mic. We may call a special meeting yet. Councillor Casper. I'm just kidding.
I'm sorry that I was absent from the last meeting. I don't know if yourself or any other council members reported on some of the outcomes that we had hopefully achieved at the UBCM in regard to meetings with ministers.
I don't remember now, but
okay.
Please go ahead.
Well, there was one topic that we all brought forward, and you asked me to lead the council delegation, and that was in regard to seeing about the feasibility of having seniors driving testing for 80-year-olds that have been required by medical to do a re-driver test, to have it done out in Souk like they have in Sydney. And I think that those who were there could attest that the minister did give a commitment and asked his staff to see what they could do to make that happen. So, that was one little bit of good news. And I know that we also had a meeting with the Minister of Finance in regard to the taxation deferment program that doesn't apply to properties in Sun River. And that was a big concern to our staff. I don't know if there was anything else.
I think we did report that out, and I also did corner the Minister of Education and asked him to support these facilities plans for school district. It was just an informal discussion. Any down this side, Councillor Pearson?
Yep, I just want to say what a pleasure it's been to sit alongside all of you. For some of you for 7 years, some of you for 4 years. It's just been my pleasure to serve with all of you. I've enjoyed every minute of it, and thank you for your service to the District of Sauk. And I wish you all well in the future. Goodbye, Ms. Ray and Ms. Berger. Extremely a lot of fun, but that goes to all of us because no one knows what's going to happen in a couple of weeks. But thank you all. It's been wonderful.
Thank you, Kevin.
No, because I do have one announcement to share, and just to advise you that the Sauk Health Planning documents have now been submitted to the Ministry. We were a part of a larger submission from the South Island Division. The deadline for that was October 1st. We had all of our ducks in a row for some time, but it was just waiting for the other areas to come on board. So that's all been handed in, and hopefully we'll receive a timely response on that for both short and long-term health needs. So it's very exciting, and I'm glad to see that that's been done. Yes, and there's no rise and report. Yes, rise and report. Sorry, motion to adjourn by Councillor Ray. Is there a seconder by Councillor Berger? All those in favor? Opposed? Carried unanimously. Good night, and thank you.